So dalawa lang po yung pagbobotohan at dahil sabi ng kagalang-galang ng puno mayoriya na kayo na po yung huling magmamanifest, tutungo na po tayo doon. Pwede na tayo doon.
Maraming salamat po.
With that, Mr. President, and no member wishes to interpolate. The minority leader is also seeking the floor. I move that
The
he be
minority
recognized,
leader
Mr.
is
President.
recognized. What is your pleasure, sir?
Thank you, Mr. President. Just one last push, so to speak.
The gentleman may proceed.
We're not saying that we defy the Supreme Court decision. We're simply saying, wait. Patience is a virtue. Yung analogy kasi na sa panliligaw, dismiss mo na kagad. Although merong mga matintimang birheng bumigay. Mas magandang analogy ito, Mr. President. In a basketball game, crucial, finals, world championship, merong review ng foul ang referee. Review muna. Dahil may foul eh. Ang gusto ng isang team, maglaro pa rin kahit nire-review. It's as simple as that. So, why not listen to the possibility of not dismissing but not accepting to table. And then we can bring it out anytime. Again, dun sa sinasabing Supreme Court has never considered a unanimous. It has. And the Supreme Court also spoke. Sabi nila, the immediately executory, they are not considered final until the lapse of the prescribed period without a so and so and so. Supreme Court din mismo may sabi niyan eh. Yun lamang po. Hopefully, kung speculation ang pinag-uusapan natin, stating that the Supreme Court will not reverse its unanimous decision is also speculative. So, pagbigyan natin to, Mr. President, tumusunod tayo, pero ilagay naman natin sa lugar. Medyo, ang Senado naman dapat itaas natin ang integridad, reputasyon. Hindi tayo, pag sinabi tumalon, tatalon. Pakinggan naman natin muna dahil maraming mali eh. Maraming error ang House. May error din yung Supreme Court decision, obviously. So you cannot right a wrong by another wrong. Thank you, Mr. President.
Noted. Senator Allen.
Mr. President.
Mr. President. Mr. President.
Yes, Mr. President.
So, I'm discussing with the minority leader, trying to pursue a wording that will articulate our collective intent of the Senate. May I just mention and have a few, maybe 2 minutes with what Senator Risa, the esteemed senator, said. Yung spirit kasi ng Constitution, once ka lang pwede ma-impeach sa 1 taon. At very clear po, pati po yung esteemed, I do recognize our the former chairman of the COMELEC, who, if he did not qualify me, I would not have become a councilor. Christian Munsod, our esteemed legal luminaries are here po. Alam niyo po, in all the books nakalagay doon, bakit may 1-year ban? Kasi nga, hindi daw dapat guluhin ng guluhin yung impeachable officer all throughout the year. Dapat isa lang. So yung spirit ng decision, nung sinabi ng BARD na, bigyan mo siya hanggang 1 year, hanggang February 6. Pero lumabas tayo sa legal. Ipa-floating muna natin to. I-dribble muna natin. Tignan muna natin. When is the soonest that the Supreme Court can decide? The next 15, 30 days? By September 1, simula na ng budget hearing sa House. By late September, simula na tayo sa Senate. Baha, DepEd, gamot, trabaho, lahat yan, inaasikaso natin. Kung walang choice at isasabay natin impeachment hapon, impeachment umaga, legislation, bakit hindi? Pero hindi ba dapat bigyan din natin ng katahimikan yung ating bansa at least until February 6? Na sinabi na ng Supreme Court, barred, mali ang proseso, tuldukan na rin natin sa Senado. So, ang isa na lang po ang pinag-uusapan natin, which I want to give honor and thank the minority leader na, pero may appeal. So, whether or not the Senate says tuldukan na natin, nandun pa rin sa Supreme Court yung appeal. Would it be acceptable both to Senator Marcoleta and to the minority? What if we word the motion that we move to adhere to the decision of the Supreme Court in Duterte versus period? Huwag na natin ilagay sa dulo kung dismiss, area. Merely adhering. Kasi nasa decision naman, nasa loob na naman decision na void ab initio and executory right away. So I don't know if that's acceptable. No? I'm trying to think of a word. Adhere, even obey kasi baka ma-misinterpret na because some of us say na wala tayong choice to obey, some think na wag tayo subservient, di ba? But adhere might be a good word. Senator Marcoleta, are we getting closer or medyo lumayo?
I think, Mr. President, we're getting closer, except that we should put some operative words there that would indicate the closure of this very issue.
Mr. President, what if it's we move to for the Senate to adhere to the Senate to the Supreme Court decision in Duterte versus House of Representatives and hereby terminate whatever unless or until certain time na may Mr. President, may I ask the good sponsor, can we mention the appeal?
I don't think so, Mr. President. I think we can only
Because
adhere.
it's immediately executory.
I think in obedience to the decision of the Supreme Court, the Senate adheres to it and put to rest.
Let me put it another way, Mr. President. If a motion is approved to act upon the decision and to adhere to the decision, am I correct, Mr. President, that that will be the decision, that will be in our journal, and then by operation of administrative process in the Senate, everything that has to do with the impeachment will be sent to the archives?
That is correct, Your Honor. That is the
Yeah, I yield to
administrative procedure
Yes.
that will logically follow.
I yield to my colleagues, Mr. President. I'm just trying to
Senator
come up
Zubiri
with
is
a consensus.
recognized.
Mr. President, I think the operative word today, if we do decide to act on the matters, to archive, as the precedents with former Ombudsman Gutierrez and former Chief Justice Davide. My
No,
question is,
former President Estrada.
former President Estrada, my apologies. Today, one of our Senate resolutions was archived. This is resolution number 35. And it's really simple, a simple amendment to the rules. But my question, Mr. President, is nothing can stop us from pulling it out of the archives and taking it over once again in plenary. Is that correct, Mr. President?
That is correct, Your Honor. Besides, although the Supreme Court said that the Senate never acquired jurisdiction and that the articles of impeachment are void, null and void ab initio from the beginning, we cannot deny the fact that the articles of impeachment were in fact sent to the Senate, that the Senate convened and sent out certain orders and summons, and these are all part of the records. So it's but natural, although it was declared unconstitutional and that the Senate never acquired jurisdiction, for us to still include that as part of the records of the Senate because it is part of the Senate's history.
Yes, and precedence tells us that we have done so in the past.
That is correct, Your Honor.
So, would it be proper to say that it will be archived without prejudice to the decision from the final decision of the Supreme Court from the motion for reconsideration? I mean, it's the same thing, without prejudice. We do that with the bills. We approve it on second reading without prejudice. But each and every one of us here questioning second reading approval, they have 3 days in which we can act upon it.
Well, Your Honor, whether you state that or not, we can bring it out of the archives by a majority vote anyway. So it's
Yes.
it's with the pleasure of the body if
Yes.
the body will agree to include that phrase or not. But
Thank you
in
for the
relation to
clarity,
Senator
Mr. President.
Cayetano's suggestion, Senator Marcoleta, if we simply vote in your case, not the motion to table, to adhere, once that decision becomes final, meaning to say after the lapse of the period for a member who voted with the winning side, on the winning side, to seek a reconsideration, the natural effect, without being included in your motion today, would be to archive it. And by virtue of the manifestation of former Senate President Zubiri, if circumstances change, nothing prevents the body, plenary, from making the corresponding motion, putting it to a vote, and reflect the change in circumstances, if any.
That will be acceptable, Mr. President.
Thank you, Your Honor. Senator Soto?
Mr. President, somehow parallel to what you're discussing, perhaps we could consider, no, and I would like to call the attention of the original proponent of this position, Senator Alan Cayetano, who was former Speaker of the House, to adhere to the Supreme Court decision upon its final disposition. In meantime, table or archive upon whatever your pleasure would be. At least, maliwanag sa atin na upon its final disposition, na may motion for reconsideration. We're still giving that chance of a motion for reconsideration.
If I may, Your Honor, if you will indulge me, if I may state the working motion to adhere to the July 25, 2025 decision of the Supreme Court declaring the articles of impeachment null and void ab initio, and that the Senate did not acquire jurisdiction over the same. We can stop there. And then, as I said, after the vote becomes final, on Monday or Tuesday, if no one will seek a reconsideration, to archive it. If there is no change, then it remains in the archives and nothing needs to be done. If the Supreme Court reverses itself, however possible or impossible that may be, then we will entertain a motion to bring it out of the archives. Bring it out of the archives and act accordingly again in obedience to the Supreme Court decision. So,
Ang problema, Mr. President, when we say that the Senate has not acquired jurisdiction, ayon tayo sa sinasabi ng Supreme Court decision nilang ito, na maraming nagsasabi na hindi tama. Dahil tinawag nyo to ng June 9 nag-oath ang Senate President. Nag-oath yung iba ng June 10, nag-motion, nag-robe pa nga eh. Hindi naman pwedeng pampelikula lang yun, pang-TV lang yung robe na yun. You convened. So hindi pwedeng sabihin ng Supreme Court that you never acquired jurisdiction. February 5, 4:15 p.m., the Senate President's Office and the Senate Secretariat received the articles of impeachment.
I'm sorry, Minority Leader. Legally, when you say the Senate never acquired jurisdiction, it does not deny the fact that we convened. That is a totally different matter. It says that since the articles of impeachment violated the one-year ban, that we never supposedly acquired jurisdiction. Not that we never did when it was not yet barred by the Supreme Court. That factual situation still exists and is part of our records. As I said, that's why the better alternative is to archive it, because it was part of what actually happened, transpired, and it's part of the Senate's history. But having said that, without belaboring the point, if agreement cannot be reached, then we can proceed to dispose of the motion of Senator Soto, our distinguished minority floor leader, to lay the motion of Senator Marcoleta on the table, and depending on the outcome of that vote, should it not be favorable to the movant, then we proceed to act on the motion of Senator Marcoleta. If it is favorable to the movant, the distinguished minority floor leader, then there is no need to proceed with the motion of Senator Marcoleta. Senator Lacson.
Mr. President, we have to determine first if Senator Marcoleta has legal standing in filing his motion to dismiss.
He will amend this motion later. We will first decide on the motion.
So
to
there's
the table.
amendment to the motion.
Yes. And then
Thank you, Mr. President.
let's hear his motion, Your Honor.
Yes. Mr. President, the lady from Antique is seeking the floor. I move that he be
Senator
she be
Legarda is
Mr.
recognized.
President.
What is your pleasure, ma'am?
Thank you, Mr. President. It's been 3 hours and a half with the very enlightening discussions. I just wanted to clarify, and actually, may I convey that there is a sliver of a difference between the two motions, so I wanted to be clarified. The original motion to dismiss, I believe, has been amended based on the discussions to the motion to archive.
Yes.
And the motion to archive, in my understanding, based on all the explanations, would be without prejudice to the reopening of the possibility after the Supreme Court conveys its ruling on the motion for reconsideration.
Yes.
And therefore, in the possibility of the event that it reverses itself, then we would act accordingly.
That is correct, Your Honor.
On the other hand, there is a motion which takes precedence, and that has been the motion of the minority leader to lay on the table the motion. But when you see and interpret the amended motion of the original movement, Senator Marcoleta, and the minority leader's motion, it's similar because it lays on the table, or it somehow just postpones indefinitely until such time that the Supreme... And I was trying to have a unanimous vote and trying to bridge the two motions, which based on Rule 31, there is actually no motion to archive, but actually every day we archive in our referral. So because of that practice, then that motion is therefore acceptable. Having said that, Mr. President, let me just summarize what we are voting on. We're actually, and I will just say it, the very, very short dispositive portion of the Supreme Court decision. And this is the article, and I quote it, the articles of impeachment are declared barred by Article 11, Section 3, Paragraph 5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and this decision is immediately executory. I just wanted to summarize what we have been discussing for 3 hours and a half. And while my attempt to bridge the two similarly worded motions did not succeed, then we will therefore have to put it into a vote. Thank you, Mr.
Majority
Thank you,
Leader.
Mr. President. Mr. President, I think we heard enough, and I think it's about time that we dispose the motion of our distinguished minority
Mr. President.
leader
Mr.
to lay
President.
this on the table, Mr. President.
President,
So I
parliamentary
move
inquiry.
for the previous
Parliamentary
motion,
inquiry,
Mr.
Mr. President.
What
Mr.
is
President, Senator Aquino is seeking the floor.
What is the parliamentary inquiry of Senator Aquino?
Mr. President, may I get earlier Senator Cayetano talked about the differences between a motion to table and motion to archive. May I get an official response, Mr. President? Is that really the difference?
Your Honor, we have not yet heard the motion of Senator Marcoleta.
No, Mr. President, a motion to archive and a motion to table, for us laymen, it sounds similar. Sa totoo lang, Mr. President. Anong pinagkaiba niya, Mr. President?
Senator Aquino,
I mean,
what Senator Soto, that's why I prefer that we act on the motion. What Senator Soto is seeking to table is not the articles of impeachment nor the impeachment case, but the motion of Senator Marcoleta, which we haven't heard.
Okay.
So when we decide on the motion to table, the motion of Senator Marcoleta, not the articles of impeachment.
Yes. And the motion to archive are the articles of impeachment, Mr. President.
Yes.
Yun yung pinagkaiba niya.
Yes.
Thank you, Mr. President.
Senator Soto?
My motion to table was to table the motion of Senator Marcoleta.
Yes.
The
That's
motion
exactly
to
what I
dismiss.
said, Your Honor.
Yes.
Oo.
That's exactly what I said.
Ay, that is
That
not,
the motion to table pertains to the motion of Senator Marcoleta,
to dismiss.
not
Correct.
the articles of
the new one.
impeachment.
Not the articles.
The motion of Senator Marcoleta, if at all, would pertain to the articles of impeachment and/or the impeachment case.
And if I may add, Mr. President.
Senator Pangilinan?
Well, the motion to archive.
Senator Pangilinan, we're not yet there.
Well, okay. The motion to table, the motion, then frees us from the debate of whether or not we have the power as a Senate in plenary to address the impeachment complaint.
The chair said that earlier.
Yes, and therefore
We will first put
Okay.
to a vote the motion to table of our distinguished minority floor leader, which under our rules has precedence over the motion of Senator Marcoleta, although made earlier. Depending on the outcome of that vote, then we will act on the motion of Senator Marcoleta accordingly. Senator Estrada.
Mr. President, you have been listening to all the manifestations of almost all senators who stood up. Mr. President, it has been 4 hours listening to several manifestations of our colleagues, and it is about time that we decide right away the pending motions before us. Mr. President, the Filipino people are watching. The Filipino people are listening. The Senate has to act, and the Senate has to act decisively. Thank you, Mr. President.
Thank you, Mr. President. I move for the previous motion, Mr. President. On the motion of the Minority Leader, Senator Tito Soto, to lay on the table the motion of Senator Dante Marcoleta.
Is there any objection to the motion of the Majority Leader for the Senate? What is the pleasure of the Minority Floor Leader?
Mr. President, I move for a nominal vote.
The chair has every intention of doing that, Your Honor. There is a motion to vote on the motion of Senator Soto to lay on the table the motion of Senator Marcoleta pertaining to the articles of impeachment vis-a-vis and in light of the Supreme Court decision of July 25, 2025. To explain, a yes, affirmative, or aye vote supports the motion of the Honorable Minority Leader, and it therefore means that we will not act on the motion of Senator Marcoleta today. A nay vote, a no vote, means that the motion of Senator Marcoleta will not be laid on the table and that we will act and vote upon it today. Senator Lacson? Later on, we'll know the amendment. Senator Lacson, so that it's on the record, please.
So you're only referring, Mr. President, to the motion to dismiss? No, motion to table. Just the motion to table.
Just the motion to table, Your Honor, because we are not yet there. There being no objection, the motion is of the... Yes, Senator Zubiri.
Yes, Mr. President, being a former Senate President and being former Majority Leader, I'd like to ask the audience to restrain from commenting or laughing, please. Well, we are in a, for me, it's a sacred place. It is in the August chamber of the Senate that we have decorum. May we ask for decorum from those who are watching within the plenary, Mr. President.
Actually, they have been silent for the past 3.5 hours. Chair would like to remind the people in the gallery to kindly respect the processes and procedures of the
Yes.
Senate and to avoid any claps, any jeering or comments so that we can proceed with roll call vote.
Yes, with due respect, because I heard a lot of laughing after the poor gentleman from our good friend, Senator Lacson, asked only for a clarification of the vote that will happen in a few seconds.
The
Yun
Sergeant
lamang
at
po,
Arms is so
just
directed.
proper decorum, because this is a very important vote, and it's a very serious vote that will be taking place. Thank you. Mr. President.
The Sergeant at Arms is so directed to kindly maintain order in the gallery. Acting now on the motion of the Majority Leader for us to divide the House and vote on the motion to lay on the table, Secretary is directed to call the roll for nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan. Senator Cayetano Pia. Senator De La Rosa. Senator Ejercito. Senator Estrada. Senator Gatchalian. Senator Go. Senator Ontiveros. Senator Lacson. Senator Lapid. Senator Legarda. Senator Marcoleta. Senator Marcos. Senator Padilla. Senator Pangilinan. Senator Soto.
May I register my vote, Mr. President?
The Minority Leader may proceed.
Thank you. Mr. President, the Supreme Court decision is now pending appeal. It is prudent to wait for the results rather than prematurely archiving, if not dismissing, because I know for a fact, once it is archived, it is dead. So what happens if the Supreme Court reverses itself? Clear and blatant errors are present in the ruling of the Supreme Court. First, they misunderstood the legislative process in assuming that the 19th Congress adjourned sine die in February 5. Grave error. Thus effectively dismissing the first three complaints, paving the way for them to say na ano pala, yung 1 year ban binayolate. The archiving of the three complaints were done after the initiation of the fourth complaint. The 1 year ban did not set in. Second, the decision practically amended the clear mandate by the Constitution by placing a hierarchy on the modes to initiate an impeachment complaint. Parang wala na yung third option. Third, the Supreme Court retroactively applied the new definition to the present case in the violation of the doctrine of operative facts, thus voiding as well the impeachment proceedings of former President Estrada and Chief Justice Corona. They did not interpret the Constitution, Mr. President. They amended the Constitution. So lastly, the Supreme Court now has the chance to rectify these errors in its decision. So I was hoping to table the motion so that we can let us afford them this opportunity for the benefit of future impeachment processes and to uphold the clear mandate of the 1987 Constitution. All we needed to do was wait a little. And so I will have to register a yes vote. I know it will be a vote in the minority, but I have always voted in the minority in many issues in the Senate since 1992 up to the present. Always prayed I was wrong. Unfortunately, I was always right. My God, have mercy on your decision. I vote yes.
Noted. Secretary will please continue.
Senator Tulfo Erwin. Senator Tulfo Rafi. Senator Villanueva. Senator Villar Camille. Senator Villar Mark. Senator Zubiri. Senate President Escudero.
No.
Pwedeng mag-explain ng boto.
Before the explanations of vote, Chair would first like to make of record the result. With 5 affirmative votes, 19 negative votes, the motion to table the motion of Senator Marcoleta is lost. Lost. Soto. Sorry, Senator Soto is lost. No, he said the motion to table the motion of Senator Marcoleta is lost.
Yes.
Pati tuloy ako, nalito dito siya.
Mr. President,
Senator Villanueva.
if I may, Mr. President, and to go back to the first motion, raised by Senator Marcoleta. If I may be allowed, Mr. President, to amend, Mr. President, the motion, Mr. President.
The gentleman may proceed with the permission of Senator Marcoleta.
Mr. President, adhering to the immediately executory decision rendered by the Supreme Court en banc on 25 of July 2025, which held, among others, the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same. I move to transfer the articles of impeachment in relation to case number 002-2011 entitled in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
What does Senator Marcoleta say?
I accept, Mr. President.
There is a motion as enunciated by the minority floor leader. What is the pleasure of Senator Zubiri?
Yes, thank you, Mr. President. Mr. President, instead of a viva voce vote on that motion, may we be allowed to manifest our votes with a short manifestation? Mr. President, each and every one of us.
This,
Yeah, through nominal voting, Mr. President, with the permission of the body, of course.
no, I think, Senator Soto, the motion of Senator Zubiri is to conduct nominal voting and allow the members to explain their votes after casting their vote, not after everyone has voted. I think that is the tenor of the motion of Senator Zubiri.
Correct.
Ang binobotohan muna natin, amendment mo di ba? Tinanggap niya.
Hindi, yung motion na.
Tinanggap niya. So,
Yes.
Mr. President, Majority Leader, Senator Marcoleta accepted the amendment of the Majority Leader. So, what are we voting on now? May we now
The motion
hear-
as amended
Yes,
by
a motion
Senator
as
Villanueva.
amended. May we hear the motion as amended, please?
May the gentleman,
Yes.
the distinguished majority leader,
Yes,
kindly
Mr.
state
President.
once again for the record and benefit of our colleagues, the motion as duly accepted by Senator Marcoleta.
Thank you, Mr. President. Adhering to the immediately executory decision rendered by the Supreme Court en banc on 25th July 2025, which held, among others, that the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same. I move to transfer the articles of impeachment in relation to case number 002-2011 entitled in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
May we register, would anyone from the minority or those opposing the motion would like to make of record their objection before so that we can divide the House?
Yes, Mr. President,
Yes,
I
please.
object and
Thank you.
ask for a nominal vote.
Thank you. With the understanding, Senator Soto, that it is in accordance with the request of Senator Zubiri, that upon the name is called, the explanation of vote may be made, should they so desire. There is a motion duly objected to, as stated by the minority floor leader, to place into to transfer to the archives the impeachment articles of impeachment in relation to the impeachment complaint against Vice President Sara Duterte. Secretary is directed to call the roll and proceed to nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan.
Sir President, sabi po ng preamble ng Philippine Constitution, we, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessing of independence and democracy under the rule of law, a regime of truth, justice, freedom, love, equality, peace, do ordain and promulgate this Constitution. Nanumpa po tayo na susundin natin tong Constitution na to. Madali pong sumumpa, mahirap to pa rin. Madali pong sumumpa na susundin kung naniniwala tayo sa desisyon. Paano kung hindi tayo naniniwala sa desisyon? Paano kung ang tinatanggal ngayong hapon na to ay si President Marcos at ayaw kong maging presidente si Vice President Sara Duterte? Will I have the courage to follow the same decision? That is the test I apply to myself today. Tinignan ko po ang Supreme Court decision, solid po. Hindi nito inaalis ang kapangyarihan sa House to initiate impeachment. February 6 po, sigurado yan. In fact, before February 6, may quadcom na, magiging glorieta na yan soon. Tuloy-tuloy po yan, yung mga investigasyon na yon, kasi ganun ang politika sa Pilipinas. I hope yung sa baha, imbestigahan din. I hope yung sa corruption, sa smuggling, sa karami-rami nating utang, not only this administration, last administration, 10 administrations. We in this room are all for accountability, but tama yung Supreme Court sa tamang panahon, tamang proseso. Jeremiah 29:11 tells us, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you hope and a future." Plano ng Diyos, pagpalain tayo. Pero plano ng Diyos, durugin tayo. So, I remember this episode, I think it was in Twilight Zone, and it was also many, many times portrayed on television. What if nakilala mo si Hitler when he was 6 years old or when he was a baby? Papatayin mo ba siya? I think even sa psychology or philosophy classes, tinatanong to ng mga professors, what if you had that unique opportunity, nakatabi mo si Hitler nung 6 years old siya, papatayin mo ba siya? Ang hirap sagutin nun. Of course, for us who believe that thou shall not murder, ang sagot madali. But what if you could have prevented the worst human rights violations in the world, the Holocaust? What if you could have prevented such fire of fascism that it actually swept, kung hindi ako nagkakamali, nag-Time Magazine of the Year pa si Hitler. I wonder what our answer is. But I know my answer here today. If you kill Hitler when you are 6 years old, if you justify the ends by the means, you will create more Hitlers. So if the Vice President is guilty, dapat po siya ay i-impeach. Pero sa tamang panahon at tamang proseso. Nagsalita ng Korte Suprema na mali ang proseso, mali ang panahon. But yun po, Mr. President, sana kung ano ang discussion since February 5 dito na nakatuon kay Vice President Sara Duterte, sana kung sino ang guilty sa mga baha, ganun din tayo. Hindi naman siguro si Sara ang gumawa ng mga baha. Sana po kung ano ang cause ng pagkabansot or stunting, yung corruption, ganun din. Araw-araw talagang wag natin tantanan. Lastly, Mr. President, may I make an appeal to the media, our friends, the vloggers, yung iba nandito, political analysts, advocates, school deans, etc. Nakalagay kasi dito, we all agree on a regime of truth. Parati na lang ang vloggers ang nasasabihan na fake news. Alam nyo po, marami tayong political analyst ngayon, di naman sila analyst eh. Ang ibig sabihin ng analyst, provides objective, non-partisan, data-driven explanation of political events, systems, and trends. Ang ibig sabihin naman ng advocate, champions a specific cause, policy, or interest group to influence public opinion and policy decisions in favor of their positions. Wala namang masama dun eh. So kung ikaw ay advocate, sabihin mo na lang. Pero mag-a-appear ka sa TV, magpapa-interview ka, sasabihin mo political analyst. Pero gusto mo lang, bata mo maging presidente, nililito mo pa ang tao eh. Ganun din po. Ilan beses kami binugbog dito nung iba. na ang sabi, bawal daw ang isang senator judge na mag-move to dismiss. Pero sila din ngayon ang nagsasabi sa mga senator judge, mag-MR kayo sa Supreme Court. Saka kayo nakakita na hindi pwede mag-motion to dismiss? Judges dismisses cases because of no jurisdiction. Ang CA, 3 sila o 5. Hindi nyo lang nakikita sa publiko at hindi sila mag-move kasi sila lang nag-uusap. Ang Supreme Court, hindi ba dinismiss nila? Hindi ba sinabi nila no jurisdiction? Tayo kasi dito nag-usap sa hall na to. So natural, hindi naman pwedeng si Senator Batorni ay tumingin lang sa akin tapos maisip niya, dismiss. Walang manifestation dito na hindi sinasabi. My point, Mr. President, is that yung sinabi ni Mahatma Gandhi nangyayari na sa Pilipinas eh. Sabi ni Mahatma Gandhi, if it's an eye for an eye, the whole world will go blind. Let's make our stand. Ilang beses ko narinig dito sa hall na to, ang taong bayan, ang taong bayan, ang taong bayan. Hindi ba naman lahat naman tayo halal ng taong bayan eh, di ba? Hindi ba pwedeng sabihin ko na lang ang opinion ni Alang Cayetano? Isa lang naman ako eh. Ang opinion ni Joel Villanueva. Ang opinion ni Mocha Uson. Isa lang naman siya eh. Pero yung sabihin ko sa inyo, guys, ang opinion ng civil society, ang opinion ng masa, ang opinion ng taong bayan, dapat makonvict. Are we not overstepping and are we not confusing rather than enlightening our political processes? Yes, you might think this is a different Alang Cayetano from the impeachment of President Estrada, impeachment of President Arroyo, impeachment of, yung hindi natuloy na impeachment kay CJ Davide, sa impeachment ni CJ Corona. But aren't we supposed to be wiser? At hindi ba tama naman yung sinabi ng Supreme Court? Dapat may impeachment, pero hindi dapat gamitin ito ng magkalaban lang sa politika. Ayaw natin maging presidente si Vice President Sara, talunin nyo na lang sa 2028. Ngayon, kung talagang may ginawa siyang masama, edi impeach, pero sa tamang paraan. I apologize if I'm emotional on this issue, but hindi tayo makawala eh. Ang daming mas importanteng issue, pero nakapako tayo sa issue na to. Thank you, dear colleagues, and thank you to Filipino people for the opportunity to share my thoughts on this. So I vote for the motion of Senator Marcoleta.
Secretary will proceed.
Senator Cayetano Pia.
I vote yes, Mr. President, and I will explain my vote.
The lady may proceed.
Thank you. Why are we here today? Why do I have to cast my vote? It is because a group of citizens, including the members of the House of Representatives, exercised the right to impeach an impeachable officer. Under the Constitution, there are two ways to file a verified complaint for impeachment. Article 11, Section 3.2 by any member of the House of Representatives or by any citizen. And Article 11, Section 3.4 by one-third of all members of the House of Representatives upon a verified complaint or resolution. There were 4 impeachment complaints filed. December 2, December 4, the third on December 19th, and the 4th complaint was endorsed by 215 members of the House on February 5, the last day. On February 18, 2025, Vice President Sara Duterte filed a case with the Supreme Court to question procedural and substantive due process. Her arguments: the House of Representatives circumvented the constitutional one-year ban rule on initiating impeachment proceedings. I won't go into the details, Mr. President, but I will submit my full speech into the record. Vice President Sara's prayer was for the Supreme Court to issue a TRO as well as a writ of preliminary injunction to enjoin all respondents from proceeding with the impeachment trial. After proper proceedings, issue a final injunction, nullify and set aside the 4th impeachment complaint, declare the one-year bar to be applicable from the filing of the 1st impeachment complaint, declare the 4th impeachment complaint to be violative of the one-year bar under Section 3.5, Article 11 of the Constitution. Sa madaling salita, ang prayer po ni Vice President Duterte ay pigilan ang impeachment proceedings dito sa Senado. In the comments of the HOR, they argued the complaint is not barred for the following reasons. None of the first 3 impeachment complaints were referred to the House Committee on Justice, which effectively ended the initiation process. And 2, Petitioner Duterte is stopped from questioning the freezing of the first 3 impeachment complaints for not immediately assailing it. Ano naman ang sinabi ng Supreme Court? The Supreme Court said the articles of impeachment transmitted by the HOR to the Senate based on the 4th impeachment complaint is barred by the 1-year rule under Article 11, Section 3.5. It is also constitutionally infirm and therefore null and void ab initio. Ang ibig pong sabihin, hindi na dapat ituloy pa ang impeachment proceeding na ito dahil ang impeachment complaint na isinumite ay labag sa 1-year bar rule na nakasaad sa Constitution. Ang probisyong ito ay naglalagay ng limitasyon na isang impeachment complaint lamang ang maaaring maisulong sa loob ng 1 taon. Dahil sa paglabag na ito, ang impeachment complaint na ito ay itinuturing na labag sa konstitusyon at walang bisa mula sa simula o tinatawag na null and void ab initio. Mahaba po yung diskusyon ng Supreme Court dyan, makikita ho yan dun sa kaso, dun na lang ho sa isusumite ko, mababasa po doon yung ine-emphasize ko na provisions. So in final, sabi ng Supreme Court, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. And this decision is immediately executory. Ano ho ba ang ibig sabihin ng immediately executory? Ibig sabihin po nito na notwithstanding the filing of a motion for reconsideration by the House, the Supreme Court's decision is immediately executory, such that the MR will not stay the decision. Katulad po ng sinabi ko kanina, dun sa press briefing ng Supreme Court, after mag-file ng motion for reconsideration ang House of Representatives, inulit pa rin ng Supreme Court na immediately executory po ito. Ano ba talaga ang karapatan ng Supreme Court na makialam dito sa impeachment case na ito? Well, ito po yung tinatawag na judicial powers ng Supreme Court. The Constitution expressly grants judicial power to our Supreme Court. Article 8, Section 1 of the Constitution provides that judicial power includes the determination of whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Sinabi po dito, any branch, kasama po dyan ang Senado. Pwedeng sabihin ng Supreme Court na may grave abuse ang Senado. Pwedeng sabihin yon. Pwede niya rin sabihin sa House yon. Pwede niyang sabihin sa kahit anong branch of government. Yan po ang nakasulat sa ating Constitution. In Francisco versus House of Representatives, the Supreme Court ruled that and the judiciary in turn with the Supreme Court as the final arbiter effectively checks the other departments in the exercise of its power to determine the law and hence to declare executive and legislative acts void if violative of the Constitution. So sinabi talaga dito, possible na ang Executive Act, ang Legislative Act ay maging void. In case of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between the several departments and among the integral or constituent units thereof. The House of Representatives urged the Supreme Court to exercise judicial restraint. Sabi ng House, hinay-hinay lang, Supreme Court, so that you can avoid encroaching upon the powers of the legislature and violating the principle of separation of powers. However, the Supreme Court in Duterte versus HREP held that there is a clear and demonstrable textual commitment in the Constitution for the court to act on any grave abuse of discretion of any branch or instrumentality of government. This includes the House of Representatives or the Senate in their exercise of their prerogatives with respect to the process of impeachment. Grave abuse of discretion from the provision does not mean actions without jurisdiction. It includes acts which originally may have been within their discretion, but subsequently the subject of a violation of a constitutional right. This is what is meant by excess of jurisdiction. This court does not decide whether and when to initiate a case of impeachment. However, the court has the power to decide how the provisions which limit the exercise are to be interpreted. On due process, numerous Supreme Court decisions expound on procedural due process in various contexts. These cases underscore the Supreme Court's enduring commitment to uphold procedural due process as a safeguard against arbitrary government action. Bakit po pumasok itong issue na due process? Kasi sinabi ng Supreme Court, hindi naman nagkaroon ng pagkakataon ang Vice President na makita ang complaint sa kanya, hindi rin nakita ang mga ebidensya. Due process exists kahit saan daw pong parte ng paggogobyerno natin. Based on the decision, in order to proceed with the impeachment proceedings, the House prosecutors must show not only a valid ground thereof, but also that procedural due process has properly been observed. As this safeguards individuals from the arbitrary exercise of government power by requiring adherence to fair procedures. As such, when there is a violation of due process as enshrined under the Constitution, the case must be dismissed. Kailangan ba ng Senado sumunod sa Korte Suprema? Sinabi ko po at uulitin ko na ang sabi ng Korte Suprema, void ab initio nga po ang kaso. Walang bisa. In Latin, void ab initio means void from the beginning. Sa umpisa pa lang, void. It indicates that something was never valid or legally effective from its inception, rather than becoming invalid at a later point in time. So sa umpisa pa lang, invalid. Hindi siya naging invalid later on, invalid siya sa umpisa pa lang. Absolutely non-existence from the very beginning. Yan ang ibig sabihin ng ab initio. Null and void. It produces no rights, imposes no duties, and affords no protection. It has no legal effect. It is, in legal contemplation, inoperative, as if it has not been passed. As such, it cannot justify an official act taken under it. Yun po ang basihan ng aking desisyon. It cannot justify an official act taken under it. Hindi ho pwede nating pasukin. Gustuhin man natin alamin. Kapareho ho ako ng napakaraming kababayan natin na gusto nating alamin kung ano ba ang mga issue na to. Pero sabi ng Supreme Court, hindi ho natin pwedeng gawin yun. We have to follow the rules. At idadagdag ko, nang sinabi nga ng Supreme Court, ay ito ay immediately executory. Again, the decision stated the Senate did not acquire jurisdiction to convene itself as an impeachment court. As such, there is no constitutional authority to even convene as an impeachment court. I am a member of the Senate and I am a lawyer. I am bound by my solemn oath. Nag-oath po tayo last week lang. Ang sabi dun sa oath, I will well and faithfully discharge to the best of my ability the duties of my position. Ginusto ko ba to? Do I want to be a judge here? Hindi po. Nung nag-aral po ako ng law, sabi ko, Lord, wag niyo akong gawing judge. I hate being a judge. Malambot po ang puso ko. Kung pwede, lahat innocent. Yun ho ang gagawin ko. Kasi napakahirap humusga ng ibang tao. But this is my solemn duty. It is my duty. I took an oath. And therefore, gustuhin ko man o hindi, I have to make a decision. And binabase ko ang aking desisyon kung ano ang sinabi ng Supreme Court. Yun naman po aming lawyer's oath. I do solemnly swear that I accept the honor, the privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of our people. I declare fealty to the Constitution of the Republic of the Philippines. Idudugtong ko yung oath na yon dun sa sinabi ng Supreme Court na kailangan sundin ang Constitution. At siya ho ang magpapaliwanag kung paano i-interpret ang Constitution. My duty as a senator and as a lawyer is to be guided by evidence, by the rule of law, and by the principles enshrined in our Constitution. For these reasons, Mr. President, I cast my vote as yes. Thank you.
Thank you, Senator Pia Cayetano. Secretary.
Senator De La Rosa.
Senator Ronald Bato de la Rosa is recognized.
Mr. President, I vote yes to the motion of Senator Marcoleta, and may I be allowed to explain my vote? Thank you, Mr. President. Last June 10, a day before the 19th Congress adjourned sine die, I stood on the same spot conveying my serious concerns on the constitutional infirmities surrounding the articles of impeachment that the 19th Congress of the House of Representatives transmitted to the Senate. I pointed out that the circumstances surrounding the filing of articles of impeachment seem to violate the one-year bar rule enshrined in Article 11, Section 3, Paragraph 5 of the Constitution, among others. Given this patent violation of the Constitution, I made a motion to dismiss the articles of impeachment against Vice President Sara Duterte. After a long discussion with the members of this chamber of the 19th Congress, I listened and I learned. My motion for dismissal was amended by Senator Alan Cayetano and became a motion to remand. The impeachment court then ordered the remanding of the articles of impeachment to the House of Representatives. This chamber also requires the 20th Congress, House of Representatives, to communicate whether or not they are willing and ready to pursue the impeachment complaint, a requirement which until now has not been complied with. In a sudden shift of events, before the opening of the 20th Congress, the Supreme Court took all by surprise when it promulgated their decision on petitions challenging the validity of the articles of impeachment against Vice President Duterte. When the Supreme Court released their decision to the media, many people expressed their views. There are those who celebrated and commended the Supreme Court. Others voiced out their disappointments. Some criticized the decision. The mixed reactions seem to suggest that the decision promulgated lacks clarity. And yet, Mr. President, after reading the decision, I asked myself, is it long? Yes, 97 pages to be exact. Is it vague? No, Mr. President, it is clear as day. According to the plain meaning rule or verbal leges, if the statute is clear, plain, and free from ambiguity, it must be given its literal meaning and applied without interpretation. Now, even though the decision of the Supreme Court is not a statute, it still forms part of the legal system of the Philippines as mandated by Article 8 of the Civil Code of the Philippines. Since the decision of the Supreme Court is clear, plain, and free from ambiguity, applying the plain meaning rule, it should be given its literal meaning. That is, the articles of impeachment are unconstitutional. The Senate did not acquire jurisdiction, and the decision is immediately executory. Plain and simple. Kaya naman, Ginoong Pangulo, nagulat ako nung ako'y tanungin, susunod po ba ako or tayo sa desisyon ng Supreme Court? Hindi po ganun kataas ang tingin ko sa aking sarili. I honestly do not place myself in a position so high, too high, that I will be the one to be asked if I will obey the Supreme Court's ruling. Ang nakasaad sa ruling na yon, immediately executory. Wala namang postscript or PS sa baba na nagsasabing subject to your review and further evaluation. As a member of the Senate and as a citizen of this republic, I submit to the authority of the Supreme Court and respect its decision. Perhaps in shedding light on the highest court's duty, the integrated bar of the Philippines said it best, and I quote, "As the final arbiter of constitutional questions, the Supreme Court bears the solemn duty to interpret the law, determine its bounds, and clarify its implications, even when it revisits past doctrines or addresses new contexts. This authority is rooted in checks and balances, the very design that guards against the excesses of any branch. Mr. President, the rule of law is the foundation of our democracy. And if we are to be models of upholding the law, then it behoves us to listen and heed those who have been tasked by the Constitution to interpret the Constitution. The interpretation of the law remains lodged with the Supreme Court, and we must abide by its decision. What message would we send out to our people if we, legislators, will not honor the wisdom of the highest court in the land? Are we not, in effect, promoting anarchy? I want to believe that indeed we are men and women of the law, that we live by rules and perform our mandate as elected officials within lawful means. Our people rest easy and feel a sense of security because their Senate has remained to be guardians of democracy. Looking back, the Senate has accepted several Supreme Court decisions in the past. Why should the ruling in this current impeachment case be any different? Is our concept of respect for and acceptance of Supreme Court decisions selective? If that is the case, are we not playing with fire? Fire, mind you, does not always intend to enlighten or illuminate. It can also burn and bring a house down. Much has been said about where I stand, and I understand that my positions on certain matters have always been consistent and transparent. But while the public and this chamber may be familiar with my views, all that is simply driven by what is in my heart. And I say this with humility. My heart has always been guided by what is right, not only when it is easy, not only when it is convenient, but even and especially when it challenges my comfort zone, when it no longer serves our side. Because at the end of the day, it is a matter of principle, not popularity. Perhaps sometimes we ought to protect our democracy, even from ourselves. Of course, the Senate is not a mere follower of the Supreme Court, but a co-equal branch, meant to respect the powers and functions of the latter in its decisions. I trust that the Senate will continue to peacefully coexist with the Supreme Court. Let us not allow this impeachment trial to become a venue and opportunity to disrupt our system of government. I hope this is not the time when we dance differently, when clearly the same song is playing. We must follow the Supreme Court ruling, not because it is the most convenient thing to do, but because it is what is right and just, no matter how unacceptable or painful it may be. And this is why, Mr. President, I vote yes to adhering to the Supreme Court decision. Thank you, Mr. President.
Thank you, Senator De La Rosa. Mr. Secretary.
Senator Ejercito.
Senator Ejercito is recognized.
Yes, Mr. President, I likewise vote yes to adhere to the Supreme Court.
Thank you, Senator Ejercito. Secretary.
Senator Estrada.
Senate President.
Senate President Escudero.
The Senate President is recognized to explain his vote.
Thank you, Mr. President. Distinguished colleagues, sa mga minamahal nating kababayan. For many of us, the past 2 weeks have proven to be an exasperating, mentally and emotionally exhausting experience. Both sides have fought bitterly a dialectical struggle to articulate what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the articles of impeachment had been constituted, the court was specifically asked, told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of its agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin to? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap? At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco, case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. Daang milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation na dapat sole jurisdiction din ng Kamara? Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagre-reklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga mahistradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at that time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance, or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law, because under our Constitution, decisions of the Supreme Court form part of the law of the land. I make these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience have been aided and abetted by so-called legal luminaries and experts who fancy their wisdom and knowledge of the Constitution as better, higher, more supreme than that of the Supreme Court. Miyembro po ba sila ng Supremist Court? Miyembro po ba sila ng Super Supreme Court? Sa pagkakaalam ko po, iisa lamang ang Korte Suprema. At ayon sa ating konstitusyon, Korte Suprema ang bukod tanging pwedeng makapagsabi kung ano ang kahulugan ng ating saligang batas. Walang iba. Allow me to demonstrate, for example, Mr. President, the legal gymnastics these people have been undertaking. In the past, and I have borne the brunt of this, sabi nila, forthwith ang sinabi sa Senado, ibig sabihin yan agad-agad. Despite the rulings of the Supreme Court that say it is within a reasonable time. Pero doon na tayo sa agad-agad. Sabi ng rules ng House, dapat i-refer ng SecGen immediately sa Speaker. 2 buwan bago niya ginawa yun. Oh, okay lang sa kanila. Di naman sila nagreklamo. Immediately po ang gamit, ha? Hindi forthwith. Sabi naman ngayon ng Korte Suprema, immediately executory. Ay, teka lang. Hintayin muna natin. Hindi pa final. Kapag ka-convenienteng gamitin yung mga salita pabor sa posisyon nila, edi okay lang. Kapag ka hindi naman, ay hindi rin. Hindi po ganun dapat yon. Hinihiling nila ngayon sa Senado na ipagpaliban muna ang anumang aksyon para intayin ang anumang desisyon ito kaugnay sa motion for reconsideration na inihain ng Kamara sa Korte Suprema. Subalit tulad ng naipaliwanag na kanina kaugnay ng motion na pinagbobotohan natin ngayon, kung magbago man ang Korte Suprema sa kanilang desisyon na unanimous noong July 25, 2025, meron pong paraan at proseso pa ang Senado para sundin ang bagong desisyon yan ng Korte Suprema kung sakasakaling mangyayari po yan. In the past, it was also said nauna nagsalita si Senator Bato, bawal daw at walang karapatan mag-motion ang sinumang senator judge. Dahil trabaho daw ng depensa yon. Eh bakit yung mga parehong tao yung pinag-uusapan? Dapat maghain tayo ng motion for reconsideration. Hindi ba trabaho din ng prosecution yon? Hindi naman po pwede na pwede lang pag kayo, hindi na pwede pag iba. Now the prosecution has actually filed a motion for reconsideration, and rightfully so, and not by this chamber. Noon kapag nung bumoto kami para i-remand ang impeachment complaint sa Kamara, pinapaboran daw namin yung nasasakdal. Sinabi ko na rin yan, na yung kontra sa impeachment at pabor sa impeachment, hindi ko didinggin. Na yung kontra at pabor kay Vice President Sara Duterte, hindi ko didinggin. Dahil may rason kung bakit babaeng nakapiring ang mata ang simbolo ng ating hustisya, na humahawak ng espada sa kabilang kamay at panimbang sa kabilang kamay. Dahil wala po dapat kinikilala ang hustisya na personalidad. Sino man ang nasasakdal, dapat pareho lamang po ang ating mga magiging desisyon. Sabi din nila, will of the people daw ito. Eh sino ba si people? Balikan po natin ang naging desisyon ng Korte Suprema. Ayon sa desisyon ng Korte Suprema sa panunulat ni Justice Malcolm sa Alejandrino versus Manuel Quezon, pinag-aaralan po ito ng mga first-year law students. Quote, the judiciary under its powers to interpret the Constitution and the laws has the duty and the right to declare what the will of the people is as expressed in the fundamental law of the land. Hence, where the acts of the executive or legislative departments violate the will of the people as expressed in the organic law of the land, it is the sworn duty of the judiciary to interpret and to declare that will of the people and the right of the citizen has been violated and or transgressed. Allow me to answer a few more, Mr. President, Your Honor. As I stated earlier, sabi ng ilan, hintayin natin na maresolbahan ang motion for reconsideration. Pero dun sa parehong araw na naghain ng motion for reconsideration ng Kamara, nagsalita ang tagapagsalita ng Korte Suprema at sinabing immediately executory pa rin ang desisyon. Sinahit ko rin kanina ang Section 1, Rule 16, AM number 10-4-20 ng Supreme Court na nagsasabi na ang resolusyon ay magiging executory lamang kapag ka ito'y nagkaroon ng entry of judgment maliban na lang kung sinabi sa desisyon na ito'y immediately executory na siyang nangyari sa kasong ito. Binanggit din kanina ni Senator Cayetano ang Section 4, Rule 39 ng Rules of Court na nagsasabi na immediately executory na mga desisyon ay hindi kailangan maghintay na maresolbahan anumang apela o motion for reconsideration na nakabinbin. Ginagamit din ang operative fact doctrine. Ang operative fact doctrine po ay exception sa rule ng null and void ab initio. Ito po ay hindi rule, ito ay exception sa rule. Gamit po ang sinulat na desisyon ni Justice Tony Carpio sa League of Cities versus Comelec. Ito ang sinabi po niya. The invocation of the operative fact doctrine is an admission that the law or act is unconstitutional. Bago po natin sabihin, gamitin natin to. Aminin niyo muna. Illegal at bawal ang ginawa ng Kamara. Sa parehong desisyon, sinabi din ni Justice Carpio, it will open the floodgates to wanton enactment of unconstitutional laws and the commission of unconstitutional acts and a mad rush for their immediate implementation before the court can declare them unconstitutional. This view, according to him, is an open invitation to serially violate the Constitution and be quick about it, lest the violation be stopped by the court. Sinabi din po ni Justice Carpio sa desisyong Aralio versus Aquino, those who acted in bad faith with gross negligence cannot invoke this doctrine. Hindi po pwedeng pakinabangan nung taong gumawa ng unconstitutional at illegal act ang doktrinang ito. Pwede lamang po itong gamitin ng mga partidong walang kinalaman dun sa ginawang mali, masama o di naaayon sa saligang batas. Ika nga, he who comes to equity must come with clean hands, and he who seeks equity must likewise do equity. Mr. President, distinguished colleagues, kinundina din ng ilang legal luminaries tulad ng Philconsa na dating pinangunahan ng nanguna sa impeachment complaint na si Speaker Romualdez, ilang taon lamang ang lumilipas, na hindi daw, bagong requirement daw ang due process. Dagdag daw ito. Mr. President, Your Honors, they should read Francisco again. They forgot that lack of due process in the impeachment process had been raised and in fact was specifically mentioned in the separate concurring opinions. And allow me to quote the concurring opinion of Justice Panganiban. The due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. It is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with number 1, notice, and number 2, opportunity to be heard prior to being impeached, are also unconstitutional. Needless to say, the due process limitation on the impeachment process was already discussed in Francisco. May pumalag ba nun? Wala. Yung nagre-reklamo ba ngayon kaugnay sa bagong requirement yung due process, nag-react nung sinulat ito at naging bahagi ng Francisco ruling? Hindi ko rin po napansin. Sinabi din po ng ilang legal luminary, partikular binanggit din ito ni Speaker Romualdez, when the court begins to create rules on how it and other high officials may be impeached, it risks writing the terms of its own immunity. This point was also discussed in Francisco. Ang sabi ng korte nito, illogical ito at non-sequitur. Alalahanin po natin. Hula lamang yung gagamitin din ito pabor sa kanila. Sa kaso ng Francisco, nakaupong Chief Justice ang nasasakdal. Pero sinabi mismo ng korte, hindi bali yan. Hindi namin pinapaboran ang kabaro namin sa pagbaba namin ng desisyong ito. Mr. President, the Constitution establishes a system of checks and balances, not a system of retribution. Threatening the Supreme Court with impeachment simply because one disagrees with the ruling is a dangerous assault on our constitutional order. The Senate, Mr. President, stands ready to uphold the integrity of the Constitution as well as the institutions created under it. My dear colleagues, we are told that to honor the court's ruling is to betray the truth, that by choosing fidelity to the law, we somehow abandon accountability, but nothing for me could be further from the truth. To this regard, the ruling would not only defy the Constitution, it would drag the nation into a crisis it can ill afford. It would erode the authority of our laws, embolden those who believe they are above it because they know it all or simply know better. To those seeking to disregard the Supreme Court's decision, I ask these simple questions, Mr. President. Again, in light of the Francisco ruling on former Chief Justice Davide, and it was okay then because they did not want then Chief Justice Davide to be impeached. Are you truly for accountability or simply anti-Duterte? Do you truly respect and want to preserve the Constitution or you simply hate the Vice President? Are you serving the nation's interest or protecting and pursuing your own personal ambitions or agenda? Are you fighting for truth or are you simply after revenge? Do you really want a trial or do you just want a conviction? Do you really believe that we are wrong or do you simply think and feel entitled and believe that you are always right? Remove the name, Mr. President, of the Vice President in this case. Apply the decision of the High Court, as Senator Cayetano said earlier, to another impeachable official. Would your positions be the same? When I was faced with this situation, Mr. President, I respected the court's decision, even if I disagreed with it. I'm still voting to respect that court's decision. As quoted at the start of my speech, Mr. President, the dispensation of justice over the course of time should be unaffected, whomsoever stood to benefit or suffer therefrom. The courts should be unafraid of whatever imputations or speculations could be made against it by those disagreeing. I will not cast a vote that says complying with the Supreme Court ruling is optional. Anyone who will say, I will respect the Supreme Court today and condemn it tomorrow, is not showing fidelity to the Constitution. It is submission to the passions of the day, to the shifting winds of public sentiment that may or may not be just. Fidelity to the Constitution, Mr. President, must prevail even when it is unpopular, inconvenient, or misunderstood. In fact, Mr. President, distinguished colleagues, it must prevail especially when it is unpopular, when it is inconvenient, and misunderstood. Finally, Mr. President, let today's verdict be a stern and unequivocal warning to anyone who would dare use the Senate for their personal battering ram to further their personal political ambitions. To the House of Representatives, I say, do not allow yourselves to be used for the blind hatred and ambition of a few who did things haphazardly, gravely abused their discretion, and violated due process rights under the Constitution as found by the High Court itself. In spite of all these, you expect everyone to roll over in obedience. When we did not, you moved hell and high water to destroy personalities, malign reputations, and tarnish institutions. To these people, I say this: the Senate is not your playground to run after your political enemies. We are not an accomplice in any grand scheme. While others may be willing to play your game, I am not. I will never bow to a mob. I will never cower to the shrillest of voices. Let history, Mr. President, record that in this moment, we chose the Constitution. We chose the rule of law by defending the integrity of the Supreme Court and maintaining the system of checks and balances under our Republican system of government. Let this chamber be remembered, not for the passions we inflamed, but for the principles we upheld. I vote yes to the motion, Mr. President. I vote yes to the rule of law, yes to the Constitution, yes to the supremacy of the Supreme Court in interpreting it. Thank you, Mr. President.
Thank you, Senate President.
Secretary will please continue to call the roll
Senator Estrada.
for nominal voting. Senator Estrada is recognized.
Thank you, Mr. President. Mr. President, esteemed colleagues, more than 190 years ago, Justice Joseph Story warned that impeachment requires a lofty sense of duty, a deep responsibility to future times, as well as to God. His words remind us that we serve not only the present, but generations yet unborn, and that our actions must be anchored in constitutional fidelity and historical consciousness. With that solemn duty in mind, may I address the decision of our Supreme Court. Mr. President, the decision of the Supreme Court is very clear, that it left no doubt nor space for any other interpretation. Accordingly, I place on record my position in adhering to the Supreme Court's ruling, a decision that declared that the Senate did not acquire jurisdiction over the impeachment case against Vice President Sara Duterte because the complaint transmitted to us was null and void ab initio. Bakit natin ipinipilit ang isang bagay na malinaw na wala sa ating kapangyarihan? Nagsalita na po ang Korte Suprema. Hindi saklaw at walang jurisdiksyon ang Senado. Tapos na ang usapin. Patay na ang kaso. Mr. President, we must never forget that the Supreme Court is the final interpreter of our Constitution. It is not merely one of three co-equal branches. It is the guardian of the rule of law. If we, the very makers of law, choose to defy its authoritative interpretation, then we commit an unforgivable assault on our democratic institutions, and we undoubtedly invite a constitutional crisis a breakdown of checks and balances where anarchy replaces order and chaos becomes the norm. Mr. President, let us be clear. No one is above the law. Not the President, not the Vice President, not even the Senate when it sits as an impeachment court. The Constitution is not just an ordinary law. It is the supreme law of the land. And if we betray to serve political passions or popular sentiment, then we betray the Republic itself. The Integrated Bar of the Philippines, in a statement, said that defying the High Court's ruling would, in effect, erode the very foundations of the legal order. And I agree with this, Mr. President. At the expense of sounding like a broken record, I would like to say again that the Supreme Court is the final interpreter of our Constitution. Tagapagpaliwanag ang Korte Suprema ng saligang batas. At kapag may hindi pagkakaintindihan kung paano dapat ipatupad, unawain ng batas, kabilang ang proseso ng impeachment, ang interpretasyon ng kataas-taasang hukuman ang siyang mananaig. Kaya naman, kapag nagsalita ng Korte Suprema, dapat itong igalang at sundin ng lahat. Ginoong Pangulo, batid natin na isang mahalagang mekanismo ang impeachment upang mapanagot ang pinakamatataas na opisyal ng pamahalaan na lumalabag o umaabuso sa kanilang posisyon at kapangyarihan. Sa ilalim din ng mekanismong ito ay may pagkakataon para may pagtanggol ang kanilang sarili. Kaya naman dapat na magamit at maisagawa ng tama ang proseso at masiguro na mga naatasan ng saligang batas na magsagawa nito, ang House of Representatives at ang Senado, ay tumupad sa kanilang tungkulin ng may integridad at walang pagmamalabis sa kapangyarihang ipinagkaloob sa kanila. Hindi na sana dapat maulit ang pagkakamaling nasaksihan natin mahigit 2 dekada na ang nakalipas sa kaso ng aking ama, si dating Pangulong Joseph Estrada. Kung inyong natatandaan, noong impeachment trial ng aking ama, pinagkaitan siya ng pagkakataon harapin ang mga paratang sa kanya dahil pinairal ang pansariling interes at hindi tumalima sa kanilang tungkulin ang mga prosecutors mula sa mababang kapulungan sapagkat nag-walk out po sila. Nakakadismaya, Ginoong Pangulo, na ganyan din ang nangyayari ngayon. Muli na naman nananaig ang pansariling interes. Matinding emosyon at inunang pamumulitika dahilan upang humantong tayo sa sitwasyong sinabi ng Korte Suprema na may malinaw na paglabag sa ating saligang batas. Had we decided to ignore the Supreme Court ruling and proceeded with the impeachment trial, we risk undermining the judiciary's role as the final arbiter of constitutional issues, and this will definitely create a dangerous precedent where future legislatures could just bypass court rulings they deem unwarranted. Mr. President, my dear colleagues, there should be a balance of power among the 3 branches of government, and this representation does not wish the Senate to be in a direct collision course with the Supreme Court amid calls for us to proceed with the trial. I refuse to be a part of the Senate. I refuse to be part of a Senate that defies the law, disrespects the courts, and undermines the very system of justice we claim to uphold. To my colleagues who insist on pressing forward, I ask these questions. If we cannot obey the law, do we still deserve to be called lawmakers? If we cannot respect the Constitution, do we still deserve the privilege of serving in public service? At kung ang Senado ay magmamatigas at hindi tutupdin ang tuntunin ng batas, hindi ba tahas ang pagtalikod ito sa ating sinumpaang tungkulin? Kung hindi natin kayang igalang ang batas na tayo mismo ang nagtatanggol, hindi na po tayo nararapat dito. Mr. President, political will, however passionate or burning within us, is not always the path we should take. There are moments when even our deepest convictions must kneel before the altar of the Constitution, when our desire for action must bow to the rule of law. Our strength as senators lies not in bending institutions to our will, but in bending ourselves to the will of our constitutional framework. Our true power is revealed not when we flamboyantly get our way, but when we gracefully accept outcomes that defy our preferences. Our honor rests in respecting and embracing decisions that contradict our personal beliefs. And our legacy is a democracy that works, preserved by our willingness to submit to something greater than our feelings, our pride, our ego, our very selves. Mr. President, let history show that I chose principle over pressure, law over lawlessness, and country over partisanship. We are not shirking from our responsibility, but to fulfill our highest duty, to uphold the rule of law and to preserve the legitimacy of our institutions in accordance with the Constitution. Mr. President, let us act not with haste, but with honor. Let us preserve our republic, not fracture it. I did not swear an oath to defend emotion. I swore an oath to defend our Constitution. Thank you, Mr. President.
Senator Gatchalian.
Senator Gatchalian is recognized.
Thank you, Mr. President. Mr. President, esteemed colleagues, I rise today to cast my yes vote. Respecting the unanimous decision of the Supreme Court, which has declared the articles of impeachment filed by the House of Representatives unconstitutional. The Supreme Court has decided, and as public servants sworn to protect and defend the Constitution, our duty is to respect the Court's decision and abide by the ruling. Napaka-specific po ng sinabi ng Korte, void ab initio, ang articles of impeachment. O sa madaling salita, as if walang nangyari. At immediately executory ang desisyon. Alam naman nating lahat, dapat natin sundin ang saligang batas. Hindi natin pinipili kung kailan natin gustong sundin. Hindi ito usapin ng opinyon o sariling interpretasyon. Ito ay obligasyon, pananagutan at tungkulin natin sa bansa at sa ating mga kababayan. From the very beginning, malinaw at consistent ang posisyon ko sa impeachment. Follow the law. Nung nagtipon tayo bilang impeachment court noong June 10 para magdesisyon kung ang articles of impeachment ay dapat bang ibalik sa mababang kapulungan, I voted no. I voted this way dahil importante po sa akin na mapag-usapan ng articles of impeachment sa konteksto ng isang legal, maayos at malinaw na impeachment trial. Ito ay naaayon sa mandato sa atin ng konstitusyon. Ayon sa Article 11, Section 3, Paragraph 6 ng ating saligang batas, the Senate shall have the sole power to try and decide all cases of impeachment. There is no room for ambiguity. Ito ang proseso ayon sa batas at ito ang ating tungkulin. Ang isang pundasyon ng konstitusyon ay ang separation of powers o ang pagkilala na ang bawat sangay ng gobyerno ay may kanya-kanyang kapangarihan at tungkulin. Ang executive, legislative at judiciary ay may kanya-kanyang mandato. At pagdating sa usaping konstitusyon, the final authority is the Supreme Court. Mr. President, esteemed colleagues, this representation knows and respects that we have different perspectives on the verdict of the High Court and on the impeachment itself. Alam ko na marami tayong iba't ibang paniniwala at pagtingin sa batas. Pero alam ko na alam din nating lahat kung ano ang sinasabi ng konstitusyon tungkol sa mandato ng ating mga korte. Malinaw sa Article 8, Section 1 of the Constitution na judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on any part of any branch or instrumentality of the government. Sa isang desisyon ng Korte Suprema noong 2003 sa kasong Francisco versus the House of Representatives, sinabi ng Korte Suprema na the Constitution did not intend to leave the matter of impeachment to the sole discretion of Congress. Instead, it provided for certain well-defined limits and, in the language of Baker versus Carr, judicially discoverable standards for determining the validity of the exercise of such discretion through the power of judicial review. Sinabi rin ng Korte Suprema sa Angara versus Electoral Commission na the judiciary in turn with the Supreme Court as the final arbiter effectively checks the other departments in the exercise of its power to determine the law and hence to declare executive and legislative acts void if violative of the Constitution. Maraming iba-ibang halimbawa, pero iisa ang mensahe. Mandato at responsibilidad ng ating mga korte na tingnan at i-review kung nagkaroon ng pag-aabuso, grave abuse of discretion o di tamang pagsunod sa proseso na itinakda ng konstitusyon. At gaya ng paggalang ng judiciary sa tungkulin ng ibang sangay ng gobyerno, it is our duty to respect the decision of the Supreme Court. Hindi dahil sinabi lang nila, kung hindi kinikilala at nirirespeto natin ang tungkulin nila. In this instance, following and protecting the process of the law means respecting the decision of the Supreme Court. Hindi ito simpleng pagsunod. We do not follow for the sake of following. Ang pagsunod sa batas at sa mga prosesong tungkol sa batas ay isa sa mga susi ng maayos na lipunan at pagbigay ng hustisya. Kapag malinaw ang ating proseso, madaling gumalaw, walang nasasayang na panahon, at mas madaling makita ang katotohanan. Law and order ensure consistency, and they preserve our way of life. Napaka-importante ng panahong ito. Ingatan at alagaan po natin ang saligang batas. It is not just any document or an ordinary set of rules. It is an expression of our collective vision as Filipino people. Defending and preserving the Constitution is not only our duty, it is the right thing to do. Thank you, Mr. President, esteemed colleagues.
Thank you, Senator Gatchalian. Mr. Secretary.
Senator Go.
Senator Christopher Bongo is recognized to explain his vote.
I vote yes, and I will explain my vote.
Please proceed.
Mr. President, I want to register my affirmative vote to adhere with the Supreme Court decision and to archive the articles of impeachment. The Supreme Court has already spoken in a crystal clear language. The court unanimously ruled that the articles of impeachment against the Vice President are unconstitutional. That the Senate did not acquire jurisdiction to constitute ourselves as the impeachment court, and that the decision of the High Court is immediately executory. The ruling is clear. Wala na dapat tayong impeachment na pag-uusapan sa ngayon. This principle of checks and balances of the co-equal branches of our government is the very foundation of our democratic and republican way of life. The separation of powers allocates to each branch certain powers and prerogatives that other branches may not question or interfere with. Disrupt that delicate balance and we shake, if not threaten, the foundation of our democratic system. When that happens, the people's faith in the various institutions of our government will be lessened. God forbid, we do not want to come to a point when our people no longer trust our courts. Sa ngayon, meron na pong unanimous decision ang ating Korte Suprema. Igalang po natin ito. That is why I voted in favor of the motion to adhere with the Supreme Court decision. But let me be very clear. Hindi ko sinasabi na hindi tayo sang-ayon sa accountability. Sa pagkakakilala ko sa mga Duterte, hindi sila tumatakbo sa kanilang responsibilidad. Haharapin at harapin nila ang anumang hamon ng panahon basta ginawa lamang po ito sa tamang paraan. Nabanggit din ni Vice President Sara Duterte na handa niyang harapin ang impeachment case laban sa kanya. Ang sabi ko nga noong nagsalita ako rito last June para isuggest na ibalik ang articles of impeachment sa House of Representatives upang matingnan at masigurong nasusunod ang tamang proseso. I said that justice done the wrong way is not justice at all. Marami namang mekanismo upang mapanagot ang kahit sino mang opisyal ng gobyerno na may pananagutan. Kung meron mang pananagutan, ang mahalaga ay nagagawa ito sa tama at legal na paraan. Mr. President, mag-move on na tayo upang mas magampanan natin ang ating pangunahing mandato at ito ay ang magpanday ng mga batas. Batas na makakatulong sa mga mahirap nating kababayang Pilipino. Napakarami pa rin sa ating mga kababayan ang walang maayos at disenteng trabaho. Napakaraming pamilya ang natutulog sa gabi na walang laman ang tiyan. Napakarami pa rin sa mga mamamayan nating mga nagsasangla ng kalabaw, nagbebenta ng ari-arian sa oras ng tinamaan sila ng sakit, at napakarami pa rin Pilipino ang hirap makakuha ng mga serbisyo at tulong mula sa gobyerno. Kaya magtrabaho na lang muna tayo. Nabibigyan na po ang Pilipino dahil sa ingay ng politika. Politikang hindi naman masasaing sa umaga, politikang hindi naman pwedeng magamit pambayad sa tuition sa paaralan, politikang hindi naman makapagbibigay lunas sa may mga sakit. Let us buckle down to our work. The people expect nothing less from us. Ever since, I am for peace and unity. Nakikiusap po ako na magkaisa na tayo para makapagserbisyo na tayo sa ating mga kapwa Pilipino. Maraming salamat, Mr. President.
Thank you, Senator Christopher Bongo. Mr. Secretary.
Senator Ontiveros.
Senator Risa Ontiveros is next to explain her vote.
Salamat po, Mr. President. Mr. President, I vote no. The 1987 Constitution entrusted the duty to try and decide all cases of impeachment to the Senate. Today, we are voting to abandon this mandate. I reiterate that the Supreme Court decision is not yet final. Kahit paano mo baliktarin. So, make no mistake, this was an act of the Senate. It is our institution which, in the words of colleagues, killed the articles of impeachment. Ang pinanggagalingan ko lamang po dito, pananagutan. Our people must have the power to make the highest rulers accountable. The process of impeachment is meant to question the powers that be and whether they deserve that power. In short, karapat-dapat ka ba? Hindi po dapat mahirap at teknikal ang impeachment. Taliwas ito sa intent ng framers. It should not be taxing to hold power to account. Anything that will make it easier for a public officer to evade accountability should be opposed. Ang hangad ko sana ay matulungan natin ang isa't isa. Tulungan natin ang ating mga kababayan na sagutin ito ng buo, ng may tapang at ng walang paligoy-ligoy. Ma-dismiss man natin ngayon o ma-archive ang articles of impeachment, mas mahirap i-dismiss o i-archive ang daing ng mga tao sa pananagutan at katarungan. Salamat po, Mr. President.
Thank you, Senator Risa Ontiveros. Secretary.
Senator Lacson.
Senator Panfilo Ping Lacson is recognized to explain his vote.
Thank you, Mr. President. Without the words immediately executory and the phrase on 25 July 2025, which held, among others, that the articles of impeachment are null and void ab initio and that the Senate did not acquire jurisdiction over the same, I would have voted in favor of the amended motion because I have always maintained that we must respect and not disobey the Supreme Court. But since there's still a pending motion for reconsideration filed by the House of Representatives through the Solicitor General, I believe that the July 25 ruling is by no means final until it rules on the motion for reconsideration with finality. That being said, I would rather wait, not preempt, the final ruling of the High Court. It is for these reasons that I abstain, Mr. President.
Thank you, Senator Lacson. Mr. Secretary.
Senator Lapid.
Senator Lito Lapid is recognized.
Mr. President, rinirespeto ko po at ginagala ko ang kataas-taasan hukuman. Ang boto ko po ay yes. Salamat po.
Maraming salamat, Senator Lapid. Secretary.
Senator Legarda.
Senator Lauren Legarda is recognized to explain her vote.
Mr. President, distinguished colleagues, the Supreme Court has ruled with clarity. It declared the impeachment complaint not only constitutionally barred, but void from the beginning, and further held that the Senate did not acquire jurisdiction over the matter. This decision, by express pronouncement, is immediately executory. We in the Senate are stewards of the Constitution and the rule of law. Our fidelity must be strongest precisely when institutions are under strain or pressure. To proceed as though the ruling were uncertain or optional would be a departure from our constitutional duty. This manifestation is a commitment to respect the present authority of the Court's decision while remaining open to its final word. I cast my vote without prejudice to the Supreme Court's disposition of the pending motion for reconsideration. The Court speaks, and at times it speaks again. But until it does, the Senate must not act contrary to what it has already said. For these reasons, I vote yes. I honor the decision of the Supreme Court. Thank you, Mr. President.
Thank you, Senator Legarda. Mr. Secretary.
Senator Marcoleta.
Senator Dante Marcoleta is recognized to explain his vote.
Ginoong Pangulo, noong ang ating Panginoong Diyos ay nilalang po niya yung unang dalawang tao, pinagsabihan niya rin po meron siyang isang sinabi sa kanila na para na rin po sa kanilang kapakanan. Ang sabi po niya, kayong dalawa, lahat ng nakikita ninyo na bunga ng halamanan sa inyong paligid at lahat ng mga hayop na nakikita nyo na gumagala riyan, pwede ninyong kainin para sa inyo lahat yan. Ngunit yung natatangi na puno na nandiyon sa gitna, ay huwag ninyong gagalawin. Matatagpo ang kabawalan ng ating Panginoon Diyos. Kaya lang po, meron pong isang ahas na biglang nakialam. Sabi niya dun sa babae, sinabi ba ikaw ng Panginoon Diyos na pagka kumain kayo dyan sa bunga nung nasa gitna na yun, ay kayo mamamatay? Oo, sabi ng babae. Ay, hindi totoo yun. Ang totoo niyan, pagka kumain kayo dyan, mas lalo kayong tatalino. Ito naman si babae, Mr. President, nakinig. At nung makinig siya, pinuntahan pa niya yung asawa niya. Yun po yung kauna-unahang underdesire po, Mr. President. Napakain din po yung asawa. Ano po ang ibig ko sabihin? Bakit ko po nilalahad ang pangyayaring ito? Meron na pong kapasyahan eh. Ang dami pong gustong sumausaw, ang dami pong gustong magsabi ng kaibayong pananaw at paniniwala doon sa kapasyahan na iginagalang nating lahat. Ang ibig ko po sanang sabihin, magpakaingat-ingat naman tayo kung sino-sino na lang ang nagpapayo sa atin. Kung mapapansin po ninyo ang karamihan ng nagpapayo na yan, may pagkakatulad po silang lahat eh. Una, lahat po sila hindi nila binasa ng kumpleto yung rules of procedures ng impeachment proceedings sa House of Representatives. Sapagkat kung binasa po nila yon, malamang hindi po ganun ang kanilang ibinubulong. Pangalawa, lahat po nung yun ay puro paborito po ng mainstream media. Sila na lang po yung tinatanong eh. Pangatlo, lahat po ng yun, walang pagmamahal sa mga Duterte. Ngayon, kung yung kalipunan po ng mga tao na yun, ng karamihan po sila, sa kanila ay nagsasabi, sila po yung mga legal luminaries. Tingin ko po sa kanila, yung iba ay legal mercenaries, Sir President. With all due respect to the word. Kaya po kung minsan, imbes na po malinawan ang marami po nating kababayan, nagkakaroon po ng pag-aalinlangan. Yung iba po ay naililigaw, nalilinlang sapagkat iba't iba. Kaiba yung mga paniniwala, pinipilit at gustong ipilit na yung pa yung mananaig kesa dusang kapasyahan na po na ibinaba ng Korte Suprema. Kung sa bagay nga po, sa una ko pong paghahalimbawa, Panginoon Diyos na nga po yun eh. Kinontra pa ng ahas eh. Ginong Pangulo, sa mga abogado po, palaging may biruan eh. Kasi po, sa lahat ng pagdedesisyon ng ating korte, lalong-lalo na po ang kataas-taasang hukuman, hindi naman po lahat ay agreeable. Merong partidong aggrieved siya, merong partidong masaya siya. Ngunit, sa katapos-tapusan eh, wala po tayong magagawa kundi tanggapin ang kapasyahan. Minsan po sinasabi nga natin kahit pabiro, alam mo ninyo basta desisyon ng Korte Suprema ay nagiging bahagi ng ating mga batas, maliman o tama. Yun po ay nasa Article 8 Civil Code na binanggit na po kanina ni Senator Bato. Nang sinasabi po, judicial decisions applying or interpreting the laws on the Constitution shall form part of the legal system of the Philippines. Wala na po tayong magagawa doon. Batas na po yun eh. Sa akin pong naunang talumpati kanina, Ginoong Pangulo, hindi ko na po ulitin. I will just request that my entire speech, Mr. President, be incorporated by way of preference to be included in this explanation in my voting yes for my own motion. Thank you very much, Mr. President.
Thank you, Senator Marcoleta, for your explanation. Madam Secretary.
Senator Marcos.
Senator Amy Marcos recognized to explain her vote.
Thank you very much, Mr. President. I vote a resounding yes. Sa hinabahaba kong pagsisilbi sa Kongreso, sa 12 taon na nanilbihan kami, ang trabaho ng kongrestista, sa pagkaalam ko, ay maging kinatawan ng kanilang distrito o kanilang sektor. Bakit naman ngayon ay naging tagabantay na lamang sila ng humihiyaw na dambuhalang sanggol? Ginawa ng bonjing na armas ang impeachment. Ang dating para sana sa kaayusan ng sistema, ginagawang pampagulo, panakot at sandata laban sa mga kinaiinggitan, kinaiinsecuran ng mga lulong sa kapangyarihan. Galangin naman natin ang Korte Suprema. Huwag tayong umastang Supreme Court, Supremest pa. Wala namang ganun ah. Sa mga kapatid kong senador, Paano tayo magiging dakilang mambabatas kung tayo mismo ay hindi susunod sa batas? Ang boses ng Korte Suprema ay boses ng konstitusyon. At kung sino man ang sasapaw sa boses na ito ay isa lang ang tono, ambisyon. Kaya naman, mag-move on na tayo. Magtrabaho at huwag konsintihin ang isang spoiled na bonjing. Huwag nang busugin ng pabor. Huwag nang pumayag dahil may pabuya. Huwag tayo magpalaki ng buwaya, baby pa nga ang tawag, lulong na. Sa mga mahal kong kongresista, may suggestion po ako. Ito suggestion lang naman, Huwag niyong masamain. Kesa inaatupag ninyong palitan ang pinili ng taong bayan, binoto at minahal. Bakit di nyo nalang palitan ang tao, kayo naman lang ang pumili? Ayaw paawat ng iba sa kakaflex. Ano kaya kung yung speaker nyo na lang ang paltan nyo? Kaya nyo yan. At dahil dito, bumuboto ako ng malakas na oo. Maraming salamat po.
Thank you, Senator Amy. Before the Secretary recognizes the next Senator, who are these people almost creating trouble there? Can you please trace their identities and send them out of this building? Secretary.
Senator Padilla.
Senator Robin Hood Padilla is recognized to explain his vote.
Maraming salamat po, Ginoong Pangulo. A'udhu billahi minasyaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Bismillahi wassalatu wassalamu ala rasulillahi. Assalamualaikum warahmatullah. Alam niyo po, ito na po siguro ang pinakamaligayang araw sa buhay ko sapagkat makasaysayan. Ako po ay nagpupugay at malalim na paghanga sa isinagawang paliwanagan ni Senator Marcoleta, Senator Soto, Senator Ontiveros, Senator Lacson, Senator Pangilinan, Senator Aquino, Senator Pia Alan Cayetano, Senator Rafi Erwin Tulfo, Senator Mig Subiri. Ang palitan ng mga paniniwala sa plenaryo ay simbolo ng humihinga at buhay na Senado. Nagagawa natin ang kalayaan at kasarinlan. Isang demokrasya na naririnig ang bawat naratibo. Tagahanga po ninyo ako lahat. At alam naman po ninyo, sa maiksing panahon ko rito, ako ay pro-Westminster. At ngayon, system po, system. Yan po yung parang sa UK. At yan po yung nakita ko ngayong araw na ito. Ang lahat ng mga senador ay gising, ang lahat ng mga senador ay nandito, ang lahat ng mga senador ay nagtatrabaho sa ayon sa kagustuhan kong makita ko ang bawat debate at ang bawat opinion ng bawat isa. Kaya nagpapasalamat po ako. Napakagandang araw po nito sa inyong lahat at sa ating lahat. Ngayon, mga kababayan, gusto ko pong malaman ninyo na ako po ay nagbibigay-pugay sa lahat ng nanonood sa atin ngayon. Malamang, ang sasabihin ninyo, siyempre si Robin Padilla, ang boto niyan, alam na natin. Eh, mabuti po, alam nyo na. Ang gusto ko lamang pong liwanagin ay ito. Ang nais ko, sana, ay katapusan na nito. Dismissal. Una pa lang po, bago pa lang po kami na-convene, labag na po sa kalooban ko na matuloy ito. Nakita niyo naman po noong nagkasumpaan, talagang ipinaglalaban namin na politika ito. Politika ito At kailangan ng due process. Pero natuloy pa rin po, nag-convene pa rin. Pero hindi pa rin po ako nagsuot ng robe dahil para sa akin ay protesta. Dahil ayoko po talagang matuloy. Bakit? Sa loob po ng matagal na panahon ni Bonifacio, ni Aguinaldo, panahon ni Aguinaldo, ni Quezon, panahon ni Marcos Sr., ni Aquino Sr., ni ni Aquino Jr., ni Arroyo, Marcos Jr., PRRD Duterte, HOR ngayon, at Vice President Duterte. Hindi na po tayo natapos sa usapin ng politika at yaan po ay pinagtibay ng Supreme Court sa kanyang desisyon na sinabi niya mismo, oo, politika lang impeachment, pero hindi kailanman dapat masagasaan nito ang karapatan ng tao. Malinaw at yun po ang pinaglalaban natin at kailangan dumaan sa tamang proseso. At yan po ang pinaglalaban natin. Ngayon, mga mahal kong kaibigan, pagkatapos po natin marinig ang bawat punto ng bawat isa, sana po, matapos na po ito at harapin na po natin ang mga tunay na problema ng bayan. Katulad po ng sweldo, katulad po ng agrikultura, pagkain, kaguluhan sa West Philippine Sea, sa buong mundo. Ang dami po nating dapat pag-usapan. Total, meron pa naman pong Pebrero ang sinabi naman po ng Supreme Court at ang Supreme Court naman po, ang siya naman po dapat na sinasabi ng saligang batas. Malinaw po, matagal po akong ginawang chairman ng constitutional ni dating Pangulo Mig Subiri. Pinagkatiwalaan niya po tayo, pinag-aralan po natin yan at malinaw sa konstitusyon na ang magpapaliwanag ng saligang batas ay Supreme Court. Kaya sana po, ako'y malungkot talaga dahil napunta tayo sa archive. Yung archive, binasa ko pwede pala yan hukayin anytime, kung ano man. So, hindi pa rin tayo natapos. Kaya sana po, bagamat ang boto ko ay yes, aray. Gusto kong malaman at mailagay po sa lathalan ng Senado na ako'y may reserbasyon dyan. Malaking reserbasyon ko dahil gusto ko dismissal. Tapusin na natin to. Hindi pa tayo natapos Total, nasabi na lahat. Ilang oras ang banatan. Pero hindi pa rin natapos. Kaya po, mga mahal kong kababayan, bago po ako umupo, nais ko pong malaman ninyo na ang inyong Senado ay tumatakbo. Huwag po kayong malungkot sa mga hindi pabor sa amin o sa mga pabor naman. Isa lang po ang masasabi ko. Tigilan na natin ang politika at mahalin natin ang bawat isa, magkaisa na tayo, pag-usapan natin ang mga totoong problema. Maraming salamat po.
Thank you, Senator Robin Hood Padilla, Madam Secretary.
Senator Pangilinan.
Senator Francis Kiko Pangilinan is recognized to explain his vote.
This representation votes no. Unang-una, ang boto na no ay hindi nangangahulugan na hindi natin nirerespeto ang pasya o kapangyarihan ng Korte Suprema. Lalo-lalo na't hindi pa ito pinal. Wala sa hanay ng mga senador na bumoto ng no ang nagsasabi na hindi dapat respetuhin ang pasya ng Korte Suprema. Hintayin lang ang final decision. Kung tutuusin, kung hinintay lang natin ang final decision, hindi tayo nagpasya at wala tayong ginawa na mga hakbang out of respect dahil nga pending pa, wala tayong nilabag sa pagiging immediately executory ng desisyon. Kaya, kataka-taka kung bakit kailangan magkaroon ng archiving. Pero pasya ito ng mayorya. Mr. President, bumoto tayo ng no dahil naniniwala tayo. Mas mainam sana na hintayin nga ang resolusyon ng motion for reconsideration. Dagdag siyempre dyan ang pagkilala ng prinsipyo ng co-equality sa House of Representatives. Yung interchamber courtesy, yung pagbibigay galang sa isang co-equal respeto sa isang co-equal. Kaya nais po sana nating i-lay muna yung matter on the table. To vote to archive the complaint despite the MR still pending, I believe, Mr. President, and I believe the others who voted no share this position, is premature, as the ruling may still be reversed or modified. In addition, at ito nga ang isang contention, to vote to archive the impeachment complaint, if at all, is to give the Senate the powers which are only reserved for the impeachment court, deciding, trying, and deciding impeachment cases. Precedents were cited in that the Senate and not the impeachment court acted on the impeachment cases of former President Estrada and Merceditas Gutierrez. But we submit, iba yung facts nung mga kaso na yun. In the Estrada case, supervening events led to the termination of the trial. In the case of Gutierrez, the Senate did not convene as an impeachment court. Kaya iba, apples to oranges, ika nga. We believe archiving the case is a matter exclusively within the powers and jurisdiction of the Senate Impeachment Court. Kaya lay on the table sana ang maayos na proseso under our rules. Allow me to reiterate that the final decision of the Supreme Court, yes, must be respected. The Supreme Court ruled that the impeachment court did not acquire jurisdiction, and its ruling rendered the official acts of convening as a court, of taking the oath, issuing of summons, and remanding the complaint as, for all intents and purposes, nullified. Kaya tinanong natin kanina, ano na ang nangyari sa constitutional duty and constitutional power as sole power to try and decide impeachment cases. We took an oath to uphold and defend the Constitution, and that includes our own determination whether or not the nullification of the acts of the impeachment court, an exclusive sole power to try and decide impeachment cases, if the ruling was based on the facts and not on a misappreciation of the facts. Kaya nga sana hinintay ang motion for reconsideration. The impeachment court being ousted of its jurisdiction by the Supreme Court is unprecedented, based, and sadly, as we read the ruling, the decision, based on the wrong facts. It is disturbing. The distinguished minority leader pointed out, point for point, in his interpellation and manifestation, the errors in the facts that the Supreme Court based its findings of grave abuse. I reiterate, one cannot be right with the law if one is wrong with the facts. And that's why napakahalaga nung motion for reconsideration. There is still an opportunity for the errors to be corrected, kaya nandyan ang MR. And this is the reason why we voted no. Napaka-precedent setting nitong nawalan ng jurisdiksyon ang impeachment court, nawalan ng kapangyarihan o isinantabi ang kapangyarihan, sole power of the House of Representatives to initiate proceedings, at naway sa pamamagitan ng motion for reconsideration, mabalik yung ating kaninang nabanggit na ma-harmonize yung lahat ng mga constitutional provisions na hindi nag-aaway kung hindi lahat ay mabibigyan ng legal at binding effect. The power of judicial review, the sole power to initiate impeachment proceedings, and the sole power to try and decide cases of the Supreme Court, of the House of Representatives, and of the Senate. Maraming salamat.
Thank you, Senator Pangilinan. Mr. Secretary.
Senator Soto.
The minority leader is recognized to explain his vote.
Mr. President, I have more than expressed myself on this issue. Just in addition, a lingering question. How can the Senate archive something that is not before it? The articles are before the impeachment court. Therefore, I cast a negative vote.
Thank you, Minority Leader. Senator Soto.
Senator Tulfo Erwin.
Senator Erwin Tulfo is recognized to explain his vote.
Ginoong Pangulo, mga kapwa kong senador at sa sambayanang Pilipino. Bumoto po ako ng yes sa moisyon na sumasang-ayon sa desisyon ng Korte Suprema sa impeachment case laban kay Vice President Duterte. Ito po ay hindi sa gusto kong iligtas ang Vice Presidente, kundi dahil malinaw ang sinasabi ng ating batas at mas malinaw pa ang desisyon ng Korte Suprema na ito po ay labag sa konstitusyon. Alinsunod po sa one-year bar rule, hindi maaring magsampa muli ng impeachment complaint ng 1 taon matapos ang naunang reklamo. Ayon po sa kataas-taasang hukuman, ito ay nalabag. At bilang mambabatas, hindi ako pwedeng pumikit na lang sa harap ng isang tahasang paglabag sa ating saligang batas. At para saan o ano pa ang saysay ng panunumpa natin noong nakaraang linggo sa tungkulin na nakasaad doon na that I will protect and defend the Constitution kung ito ay susuwin lang naman natin. Ngunit linawin ko ito. Ang boto kong ito ay hindi para iabsuelto si VP Sara Duterte. Sa totoo lang po, gusto ko siyang humarap sa paglilitis upang maipaliwanag ang mga issue upang sumagot sa mga tanong ng taong bayan at upang harapin anumang pananagutan kung ito'y nararapat. Dahil ang paninilbihan sa taong bayan ay hindi po pribilehiyo, kundi isa ring pananagutan. Public service is not just a privilege, rather it carries also huge responsibilities. Sa loob po ng mahabang panahon, nasanay na ang ilang matataas na opisyal kapag may kapangyarihan, may lusot. Kapag mataas ang posisyon, immune sa tanong o investigasyon. Tama na. Panahon nang baguhin ito. Kung tunay po na walang kasalanan si VP Duterte, dapat siya mismo ang manguna sa pagbubukas ng lahat ng dokumento, paggamit ng budget at mga hakbangin niya bilang pangalawang Pangulo at kalihim ng DepEd. Walang dahilan para umiwas kung malinis po ang konsensya. Ang boto kong yes ay hindi pagtatanggol sa kanya, kundi pagtatanggol sa legalidad ng proseso. Hindi po ito ang wakas. Kung may basehan at sa tamang panahon, hindi po ako magdadalawang isip na suportahang muli ang isang lehitimo at makatarungang impeachment. Dahil ang pamahalaan po ay para sa taong bayan, hindi po para sa iilang nasa puder. Maraming salamat at mabuhay po ang sambayanang Pilipino.
Maraming salamat, Senador Erwin Tulfo. Ginoong Sekretaryo.
Senator Tulfo, Rafi.
Senator Rafi Tulfo is hereby recognized to explain his vote.
Mr. President, my vote is yes. Let me explain my vote. My dear colleagues, in our Constitution, the sovereign Filipino people agreed to establish a government that will run our country. Malinaw dito kung ano ang kapangyarihan ng bawat sangay. Ang legislatura ang tagagawa ng mga batas. Ang ehekutibo ang tagapatupad ng batas. On the other hand, ang Korte Suprema naman ang taga-interpret o tagapaliwanag ng batas kapag may hindi malinaw dito o may pagtatalo kung paano ito ipapatupad. Kaya naman, ang respeto ng bawat sangay ng gobyerno sa isa't isa ay mahalaga upang tuloy-tuloy ang maayos na pagpapalakad ng ating gobyerno. Under the Constitution, it is the House of Representatives that shall have the exclusive power to initiate all cases of impeachment. Wala po tayo papel sa proseso na yan. Our role only comes when a valid articles of impeachment complaint is filed before us. Mr. President, the case before the Supreme Court is about the impeachment initiation procedure before the House of Representatives. Whether a case of impeachment has been initiated according to the text and spirit of the Constitution. Of course, I will not delve into the correctness of the decision of the Supreme Court, but I believe it is within their authority to interpret the Constitution and declare whether the actions and processes before the House is constitutional. And so, we must accord the decision of the Supreme Court the same respect that they give the laws that we enact as the legislative. That is the scope and limitation of our powers. Having said that, allow me to go to the clear, dispositive portion of the decision. Sa dulo po ng 97-page decision, ito po ang sinabi ng ating Korte Suprema. Una, the articles of impeachment are unconstitutional and are deemed null and void ab initio. In other words, walang bisa nung simula pa lang. Second, the court said, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. Ibig sabihin, hindi nagkaroon ng Senado ng kapangyarihang maglitis bilang impeachment court. Mr. President, I agree that we should abide by the decision of the court to avoid any constitutional crisis. And if I were to take the duty to my heart, I believe the decision is very clear. No impeachment court was validly convened. That's my vote. With that said, however, there are concerns raised regarding the decision. So it is important for the Supreme Court to address these concerns. I have faith in the Supreme Court that it will perform its mandate. That's all. Thank you, Mr. President.
Thank you, Senator Rafi Tulfo. Secretary.
Senator Villanueva.
The Majority Leader recognizes Senator Villanueva.
Thank you very
Explains
much,
vote.
Mr. President. Mr. President, esteemed colleagues, this representation stands today not just a senator judge, but as a member of this institution who took an oath to uphold the Constitution. And I'm here, Mr. President, to explain my vote. But more importantly, to stay true to that oath, to serve with integrity and give life to the spirit of the law. Article 11, Section 1 of our Constitution provides that public office is a public trust. Ang isang katungkulan sa pamahalaan ay isang tiwalang ipinagkakaloob ng mamamayan. This underscores one of the core principles of democracy, that ultimate political power resides with the people. And thus, the preamble starts, Mr. President, we, the sovereign Filipino people, because the government's authority and legitimacy emanates from the people. Thomas Jefferson encapsulated the expectation from a person holding public office in one sentence. When a man assumes a public trust, he should consider himself as public property. Close quote. Kapalit ng tiwalang ipinagkakaloob ng bayan sa isang tao ay ang paglilingkod ng may katapatan sa saligang batas at sumasalamin sa mithiin ng bayan na nakapaloob dito. Ginoong Pangulo, pag-aari ka ng publiko dahil ang bawat galaw at desisyon mo ay hindi para sa sarili, kundi laging para sa bayan. While due process protects life, liberty, and property, public office is not private property. As Justice Malcolm wrote in Segovia versus Noel, a public position is not owned by its holder. Ang posisyon sa gobyerno ay hindi premyo o personal na karapatan. Ito po ay pananagutan at pagtitiwala ng taong bayan. During the July 26, 1986 discussion of the Constitutional Commission, it was noted that, and I quote, a violation of an oath of office is itself a violation of the Constitution because a public official's oath is in the Constitution. Close quote. Thus, accountability is not only a moral imperative, it is a constitutional duty. Public officials are answerable to the people at all times, and the mechanisms of impeachment and oversight exist precisely because no one can claim a vested personal entitlement to office. Where accountability is demanded, due process must still be observed. Ngunit Ginoong Pangulo, hindi po ito dapat maging panangga laban sa makatarungan at lehitimong pagsusuri o gamitin upang gawing pagmamay-ari ang isang tungkulin pampubliko. Higit po sa lahat, hindi ito dapat maging kasangkapan upang takasan ang pananagutan. Wala po ni isa ang nakatataas sa pananagutan, nakakatakas sa pananagutan. Lalo na po ang mga nasa pinakamataas na posisyon ng ating bayan. Mabigat po ang papel natin dito sa Senado, Ginoong Pangulo, lalo na sa impeachment. Hindi po ito simpleng usaping legal. Desisyon po ito na nakabatay sa batas at nagmula rin sa ating prinsipyo at konsensya. The framers of our Constitution knew this. That's why impeachment decisions are ultimately acts of political and moral judgment, not just strict legal analysis. Kaya po malinaw ang disenyo ng ating saligang batas. Ang House ang may eksklusibong kapangyarihan para magpasimula ng impeachment at ang Senado ang tanging may kapangyarihan na lumitis at magdesisyon. This is a sui generis role, unique, exemptional, and deeply rooted in our democratic system. That is also why both chambers of Congress were given the authority to craft their own rules of procedure in impeachment cases. May mga bumatikos po sa atin noon, Ginoong Pangulo, sa pag-remand natin ng articles of impeachment sa House. At sabi nila, ng mga bumabatikos, pag-iwas daw po ito sa tungkulin. Pero kung susuriin pong mabuti, Ginoong Pangulo, hindi po ito pag-atras sa ating tungkulin. It was a necessary and prudent step towards ensuring that the proper procedure was followed so that our decision as a court will not be marred by legal and constitutional infirmities. Now we are faced with the High Court's decision that tackles precisely that which we hope to avert when we remanded the articles of impeachment, Mr. President. So clearly today, the Supreme Court's decision in GR 278353 is a vindication of the Senate's action. We have been called so many names, Mr. President, and ridiculed in the digital court of public opinion. I'm sure the Senate President would likely agree with this representation that the allegations thrown at us regarding the impeachment and even the decision of the Supreme Court, a matter that we have no participation in, are extremely preposterous and absurd. But this exercise, while political in nature, is not about personalities. It's not about revenge. It's not about prevailing sentiments or personal biases. It is about upholding what is legal and constitutional and what will hold true in the years that follow. Let me make one thing clear to our kababayans, mahal nating mga kababayan. We in the Senate have never abandoned our mandate in this impeachment proceeding. Ang bawat hakbang po na ating tinahak ay nakaangkla sa kaluluwa ng ating bayan, ang ating inaalagaan at pinoprotektahan sa ligang batas ng Republika ng Pilipinas. But as they say, Mr. President, dissent is not a threat to democracy. It is essential to its survival. Kaya doon po sa mga pumuna, sa mga nagsabing mali ang naging pasya ng Senado, hindi tama ang ginawa po natin dito, naintindihan naman po natin sila kung saan sila nanggagaling. And in that same democratic spirit, I now take this opportunity to respectfully air my own dissent to certain portions of the Supreme Court's decision. While we respect the court's authority, I believe there are portions of the ruling that may have inadvertently made the already difficult process of impeachment even harder. Agree po ako doon, Ginoong Pangulo. Impeachment was never meant to be easy, but neither was it designed to be impossible. The framers of our Constitution deliberately relaxed the rules to empower the people and lower the barriers to initiating accountability against high-ranking officials. The Constitution even allows any ordinary citizen to file a verified complaint. Ang mababa at mataas na kapulungan ng Kongreso ang nagsisilbing takbuhan ng mamamayan sa mga pagkakataong wasak na ang tiwalang ipinagkaloob ng publiko sa mga iniluklok nito. And yet, Mr. President, with this decision, we now see new procedural hurdles that were not explicitly required by the Constitution, including the rigid interpretations of due process at the preliminary stage. These add layers of complication to a process that is already politically and institutionally fragile. Kung hindi po natin iingatan, tama po yun. Baka po mawalan ng saysay ang impeachment. Buhay sa papel, ngunit patay sa proseso. This was no accident of drafting, Mr. President. The framers of the 87 Constitution intentionally relaxed the requirements for initiating impeachment, lowering the vote needed from 2/3 as required in the past constitutions to just 1/3 of all House members. As explained by the framers of our Constitution, this was meant to, I quote, make it easier, not harder, to hold high public officials accountable, close quote. They had lived through a time when power went unchecked and accountability was elusive. Kaya siniguro po nila na ang kapangyarihan ay laging may akaakibat na pananagutan. Mr. President, this representation did not come to this decision lightly. We understand and value the necessity of public accountability. Naiintindihan po natin yan. Napakahalaga po yan. Walang sino man po ang dapat mailagay sa pedestal na hindi kayang abutin ng batas. Pero ang pananagutan po ay kailangan dumaan sa tamang proseso. Isang proseso na hindi lamang makatarungan, kundi naaayon at tumatalima sa saligang batas ng Republika ng Pilipinas. Sa mga ganito pong sitwasyon, hindi po naaalis sa aking isipan. Kung may mga pagkakataon meron po bang pagkakataon na maaaring labagin ng Senado ang mga ipinag-utos ng Korte Suprema? Maaaring halimbawa po nito ay kung may klarong panghihimasok sa internal rules of procedure ng Senado, ang Korte Suprema. Ngunit, Ginoong Pangulo, sa pagbibigay kahulugan sa nakasaad sa ating saligang batas, tanging Korte Suprema lamang ang may kapangyarihan bilang pinal na tagapagpasya. Article 8, Section 1 of the 87 Constitution expands the Supreme Court's scope of judicial power by mandating it to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In the case of Angara versus Electoral Commission, Justice Jose P. Laurel, who later became the third President of the Republic, wrote, and I quote, "When the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution." Close quote. Noong pong tinatalakay ng ating mga constitutional framers ang probisyon sa konstitusyon patungkol po sa proseso ng impeachment, binanggit po ng kagalang-galang na Commissioner Dodong Maambong ang isang sipi mula sa isang kaso sa Amerika. Ang sabi po niya, and I quote, ang impeachment ay ang unang hakbang sa isang proseso ng pagwawasto. Ang layunin po nito ay hindi personal na pagpaparusa sa nasasakdal, bagkos ang pangunahing layunin nito ay panatilihin ang pamahalaang naaayon sa konstitusyon. This quote captures the heart of what impeachment is meant to be, Mr. President. It is not about personalities or punishment. It is about protecting the very structure of our constitutional democracy. And sometimes protecting that structure means accepting limits, even when we disagree with how those limits are drawn. In this case, the Supreme Court, as the final interpreter of our laws, has spoken unanimously, and I will say it again, spoken unanimously, decisively, and with finality. It ruled that the impeachment complaint violated the one-year bar rule. The Vice President was denied due process, and that this Senate, as of the moment, had not acquired jurisdiction. Mr. President, in closing, again, I would say we may not agree with every word of that ruling. But the rule of law is not a matter of convenience. It is the foundation of our democracy. Upholding it, even when it is difficult or unpopular, is what gives this institution its credibility and our democracy its strength. To ignore it, no matter how justified we may feel, is to risk eroding the very foundation we are sworn to defend, our beloved Constitution. Kaya po, Ginoong Pangulo, sa liwanag ng ating saligang batas at bilang paggalang sa pasya ng Korte Suprema, habang kinikilala po natin na may nakabinbing motion for reconsideration na sinampa ng House of Representatives, and in adhering to the immediately executory decision rendered by the Supreme Court, I vote to transfer the articles of impeachment to the archives. Thank you, Mr. President.
Senator Villar Camille.
Senator Camille Villar is recognized. You may proceed, ma'am.
Mr. President, my dear colleagues, I vote yes to the motion to archive the articles of impeachment against Vice President Sara Duterte, respecting the decision of the Supreme Court. It is undeniable that the Supreme Court has the power under the Constitution to declare an act of a co-equal body as unconstitutional, a power known as judicial review. The power allows the Supreme Court to ensure that all branches of the government act within the bounds of the Constitution, and it should be respected. The three main branches of our government, the legislative, executive, and judicial, each is vested with distinct powers and functions by the Constitution, none superior to others. Each operates independently with its own sphere of authority and serves as a check and balance on the others to prevent abuse of power. This is the foundation of our democracy, and it ensures the rule of law, accountability, and protection of rights of all Filipinos. In this case, the Supreme Court has spoken. By a unanimous vote, the Supreme Court declared in clear and unequivocal terms the articles of impeachment against Vice President Sara Duterte unconstitutional and null and void ab initio for violating the one-year bar rule and due process clause. As a result, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision, finally, is immediately executory. Mr. President, we have heard many good arguments in the recent weeks from both sides. Just today, being the youngest member of this robust body, I have learned so much from our esteemed and distinguished colleagues. But to me, it is simple. The opinion, or the most important opinion, is that of the final arbiter of our Constitution, and that is the Supreme Court. I have faith that the Supreme Court has done their duty and fulfilled their mandate. Being a legislator and a public servant, it is my duty to abide by that decision. Not too long ago, I took my oath of office as a senator, and I swore to support and defend the Constitution, and I adhere to that today. To do otherwise can lead to uncertainty and chaos, and even a constitutional crisis. This is what the rule of law expects from each and every one of us. And to respect the rule of law is to respect our democracy. And that is why I vote yes to the motion before us. Mr. President, dalangin ko sana na marisolba na natin ngayon ito upang mapagtuunan na natin ng pansin ang mga tunay at malalaking problema na hinaharap ng ating bansa at ng ating mga kababayan, katulad ng mataas na presyo ng bilihin, pagkaroon ng wastong hanap buhay, kalusugan at kaligtasan ng bawat Pilipino. Maraming salamat.
Thank you, Senator Villar.
Senator Villar, Mark.
Senator Mark Villar is recognized. You may proceed, sir.
Thank you, Mr. President. I rise to vote yes and explain my vote on the matter before us, and to explain why we compromised today on archiving this very important topic. But of course, we must always remember that the status quo is that the Senate has no jurisdiction. So in legal speak, this complaint is null and void. Last July 25, the Supreme Court rendered a unanimous decision declaring the articles of impeachment against Vice President Sara Duterte unconstitutional, noting that it is barred by the one-year rule under the Constitution and that it violates due process. The merits of this decision are not an issue at issue before us. The sole question we need to answer is whether the Senate should respect the decision of the Supreme Court. And I say clearly and emphatically, yes. The Supreme Court has the ultimate authority to interpret what the Constitution is. No one, including the Senate, can substitute its opinion over the courts in any matter concerning the Constitution. And the Constitution itself, in Article 8, Section 1, entrenches the court's role in interpreting the Constitution and determining whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction by any branch or instrumentality of the government. This includes the Senate, even when acting as an impeachment tribunal. Justice Laurel laid down the doctrine in the Supreme Court as the final arbiter of constitutional issues in Angara versus Electoral Tribunal, where it was stated that when the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution to determine conflicting claims of authority under the Constitution. At dahil nagdesisyon na po ang Korte Suprema, tungkulin po ng Senado na sundin ang desisyon na ito. Sumasangayon man tayo o hindi, dahil nangako tayo, bawat isa sa ating mga senador, that we will support and defend the Constitution of the Republic of the Philippines, that we commit to obeying all laws and legal orders issued by the duly constituted authorities. Nasa oath of office po natin ito. In staying true to our oath of office, we must abide by the order of the duly constituted authority in matters of the Constitution, the Supreme Court. We must uphold the Constitution. Thus, the Senate cannot acquire jurisdiction to proceed with the trial, much less issue a verdict. Tulad ng sabi ni Senior Associate Justice Leonen, the impeachment process is a constitutional process. And although it is also a political process, It is not isolated from the requirements of the Constitution as a whole. Kailangan obserbahan ang due process, ang tama at makatarungang proseso bago matanggal sa posisyon ang isang individual. Habang iginagalang natin ang opinyon at pananaw ng bawat isa sa mga importanteng usapin, kailangan natin igalang, kilalanin at bigyang halaga ang kakayahan at kaalaman ng mga maestrado ng kataas-taasang hukuman na binigyan ng kapangyarihan ng ating konstitusyon bilang huling hukom na ipaliwanag kung ano ang batas at kahulugan nito at magdesisyon ng pinal sa isyung ukol sa konstitusyon. By recognizing the authority of the Supreme Court on the matter, the Senate does not abandon its mandate and its wisdom as an independent political body, nor does it concede or submit to a co-equal branch of the government. We are simply upholding the rule of law. At kung susuway tayo sa desisyon ng Supreme Court sa isang isyung konstitusyonal, binabaliwala natin ang konstitusyon. Ito ay magdudulot ng isang krisis sa ating saligang batas at lipunan na hindi makakabuti para sa taong bayan. As a functional society governed by the rule of law, we must accord our democratic institutions with respect, value their guidance, recognize their competence, and cherish their independence. Mr. President, pinapatunayan ng desisyon na ito na makakaasa ang tao na ang due process ay hindi lang guni-guni o kasabihan walang katuturan. Na ang due process ay para sa lahat at hindi lang para sa mga kakampi. Isang patunay na mapabisi presidente man o ordinaryong Pilipino, makakasigurado tayo na ang mga institusyon, ang Korte Suprema at ang Senado ay handang ipagtanggol, pahalagahan at bantayan ang ating mga karapatan. Without the rule of law, people may act without accountability, government leaders may act on personal interest, individual rights can no longer be guaranteed. Without the rule of law, there can be no justice, no order, and no real democracy. To end, I would like to quote Supreme Court Senior Associate Justice Leonen, who penned the decision. There is a right way to do the right thing at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment. Maraming salamat po.
Thank you, Senator Villar. Before recognizing Senator Zubiri, I'd like to thank him for his patience because he's always last whenever we do nominal voting. At some point in time, you might want to make a motion, Senator Zubiri, for us to draw lots on which letter of the alphabet we will start voting.
Thank you.
The gentleman may proceed.
Maraming salamat, Mr. President. Alam mo po yun, Ginoong Pangulo, dahil magkasama po tayo sa Kongreso ng 3 termino. At dun sa 3 termino, na alam ko yung bilang po natin ay 265, 268 congressmen, napakahirap po pag ang iyong pangalan ay nagsisimula sa letrang Z. Kasi ako po ay palaging huli. Minsan po, wala na pong tao nakikinig sa akin. Yung janitor na po, mga page ang nag-aayos ng mga upuan. Pero, subalit na yung araw na ito, nagpapasalamat ako at napakarami pang senador na nandito po na yun. Nandito si Senator Bato, Senator Bong, Senator Robin Padilla, Senator Amy, Senator Erwin, Senator Mark Villar. Our Senate President Pro Temp, who's not listening, but he's here with us today, together with the movant, Senator Marcoleta, and all the rest, no? Nandito ang 2 Cayetano na kaibigan natin. Yung mga seatmates nandito and minority. Pero Mr. President, honestly, it pains me to vote against my minority floor leader. It pained me and Senator Lauren. But what we are called to do here today goes beyond a simple vote. We all know that, Mr. President. It goes beyond a simple vote. Rather, for me, it's a test of our commitment to our Constitution and the rule of law. When the House of Representatives transmitted the articles of impeachment to us in February 5, 2025, my position was clear. We must go ahead with the trial, as this is our constitutional duty. In many interviews, that's what I said. It doesn't matter how I feel about it, because many people already said that I was on the other side. But I've said it doesn't matter what my personal feelings are. What matters is that we proceed with our constitutional duty. When the motion to remand the articles of impeachment came up on June 10, 2025, it was also my position, again, clear, that we must remand the articles not for the sake of dismissing the trial, Mr. President, but for the purpose of ensuring that the House of Representatives had not violated the impeachment process as laid out in the Constitution. I have always upheld the principles of rule of law and the primacy of the Constitution, and I've consistently shown the highest respects for the Supreme Court as the final arbiter of all constitutional questions. So today, again, my position is clear. We must respectfully adhere to the Court's ruling that the current impeachment complaint is unconstitutional. Our Constitution expressly empowers the Supreme Court to review even the article or the actions of political branches. In Francisco versus House of Representatives, that case which has been mentioned by almost all my colleagues here, the court affirmed that it is the final arbiter for constitutional questions with authority to strike down acts that violate the Constitution. Thus, I vote to support the Supreme Court on not to proceed with the trial of the articles of impeachment as it violates both the Constitution and the guarantees of due process, rendering the current complaint unconstitutional and void ab initio. The grave denial of due process only magnifies its fatal defect. Without jurisdiction, any trial would be meaningless and any verdict null and void, Mr. President. To disregard the Court's unanimous ruling would be to invite a constitutional crisis and to break our oath to support and defend our Constitution. The power of impeachment is not without limits, Mr. President, my dear colleagues. It must be exercised within the boundaries set by the Constitution as interpreted by the Supreme Court. And let me be clear for those listening tonight. The Court did not place the Vice President beyond scrutiny. It simply required that any future impeachment follow constitutional safeguards. As simple as that. A new complaint may be filed by February 6, 2026, lawfully and with due process, at doon na po natin magagamit, Senator Kiko Pangilinan, yung ating mga gown at robe. Kasi sigurado, as the day will shine tomorrow, there will be an impeachment case filed against her. And we will be ready. This time, we will be prepared and follow the due process that was mentioned by the Supreme Court. I speak, Mr. President, as someone who's been a legislator for over 2 decades now, together with the Senate President, long enough to know that our fragile democracy rests on the strength of our laws, that our freedoms are given shape by our rules and traditions. And you all know me as a stickler for rules and traditions, together with my minority leader. I have served in both houses, House of Representatives and the Senate, and here in the Senate, being formerly a majority leader, the Senate President, and now your Deputy Minority Leader. In all these roles, Mr. President, I've been conscientious in adhering to the rules and traditions that protect the integrity of our beloved institution. It is in this spirit that I adhere to the Court's decision. My vote today is based on the Supreme Court's decision last July 25, 2025, without prejudice to whatever resolution it may later render on the motion for consideration. That's why I thank the good movement, Mr. President, to allow me to amend or to allow the amendment of his motion to make it a mere archiving of the document, because that will never stop us from being able to pull out that document from the archives. Maraming salamat sa ating mahal na movement, si Senator Marcoleta. let me just say this, Mr. President, to end my manifestation and my vote. Restraint is not weakness. It is obedience to constitutional order. Let us act not in defiance of, but in deference to the Constitution, to the Supreme Court, and to the people who have entrusted us these powers in this very chamber. Daghan kay salamat sa ako mga kaigsunan, and may God bless us all. Maraming salamat, Mr. President.
Thank you, Senator Zubiri. With 19 affirmative votes, 4 negative votes, 1 abstention, the motion of Senator Marcoleta, as amended by Senator Joel Villanueva, adhering to the immediately executory decision rendered by the Supreme Court en banc on July 25, 2025, which among others held that the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction, and to move to transfer the articles of impeachment in relation to case number 002-2011, entitled "In the Matter of the Impeachment Trial of Vice President Sara Zimmerman Duterte," to the archives. The same is hereby approved.